In our preamble, we have information about zooming in, but it really pertains to individuals who are not familiar with the process. And so I will skip over that information. But I will start by saying that I would like to acknowledge that we are in Treaty 1 territory and the traditional homeland of the Métis Nation. The members of the panel with me today are Brent McIntyre and Lynn Nesbitt. Our secretary is Michelle Neepin, and the assessor today is Ryan Valderrama. We'll be hearing applications for revision of the assessment roll in accordance with the Municipal Assessment Act. The matters for which revision is requested have been described in each application, and we will limit discussion to those matters. The statements that are made at this hearing are sworn testimony, and anyone speaking to the matters must be sworn in. Be advised that comparisons of assessments of properties are not considered evidence of market value by the Board of Revision. The Board of Revision is appointed annually by Council and is independent of it and the City Administration. It makes its decisions on the basis of the evidence provided at this hearing and issues a written order that will be mailed to all parties as soon as possible. Please note that the Board's decisions with respect to an application may be appealed to the Manitoba Municipal Board if the matter pertains to assessed value or classification, or to the Court of Queen's Bench if the matter pertains to the application of exemptions from taxation. Should you wish to appeal, information on how to do so will be included with the Board's order. With respect to the hearing process, I will confirm the points of appeal with your property to be addressed with each applicant following the swearing in. We will then have the assessor's testimony followed by questions that the applicant may have, and then the applicant's testimony followed by questions. Each side will have an opportunity to summarize if they wish. Once all the evidence about an application has been brought forward, the applicant may leave. The process will repeat for each item on the docket today. The session will close after all the applications have been heard, and the Board will deliberate in private and make its decisions. You'll receive the Board's decision by registered mail as soon as possible. As information, all public hearings are live streamed, recorded, and will be part of the public record. Use of cell phones is not permitted except by the approval of the chair, but I think maybe that doesn't apply if you're zooming in like I am. So with that, could we have the swearing in of the parties?
Mr. Valderrama, we'll start with you.
Yeah.
Okay, can you state your full name, please?
Ryan Valderrama.
Do you affirm that the evidence you're about to give this hearing should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. Dupuy, are you giving evidence today?
I doubt that I'll give evidence, but I swear me in.
Yeah, okay. Can you state your full name, please? Sorry, can you state your full name?
Oh, Brian Paul Dupuy.
Do you affirm that the evidence you're about to give this hearing should be the truth, the whole truth, and nothing but the truth?
I will, yes.
And Ms. Lombard, do I need to swear you in? Sorry, you're on mute.
Can you hear me now?
I can hear you, yeah.
Perfect. Yes, I would be swearing in.
Okay, can you state your full name, please?
Kaylin Bethany Bomback.
And do you affirm that the evidence you're about to give us this hearing should be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. And Mr. Reiner,
Yes.
can you state your full name, please?
Kerry Ralph Reimer.
And do you affirm that the evidence you're about to give us this hearing should be the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you very much. On the docket today, we have properties that are carried over from November the 3rd, I believe it is. Some of those properties were actually removed from the roll and combined. All the ones on Elgin Avenue have now been combined into the address 319 Elgin Avenue. And a supplementary tax notice had been issued on that property, rendering the previous appeals null and void. And we now have just a single property on Elgin Avenue. As I recall, the principal issue here is class and liability. However, given that several of the Elgin properties have been combined into one. Is one of the issues at stake here the value on Elgin Avenue as well, or is it only the class and liability?
Mr. Chairman, I can answer that. We are not disputing the value. It is strictly class and liability.
Okay. So in other words, there won't be a value discussion with any of these. It's all class and liability.
Indeed.
All right. Well, that sounds rather like you would start us into this, unless anybody else has preliminary issues that need to be raised.
Thank you, Mr. Chairman. Recall, if I could ask the board members and the members of the Assessment Department, City Law Department to refer to our main brief. This is the lengthy initial brief that was filed. And recall, Mr. Chairman, that this brief, the issues that we're going to be discussing do relate strictly to primarily liability to taxation, and the issues are common to all of the properties. There's a couple of wrinkles in there that I will be getting into later in the presentation, as it involves the main campus because of its size, and actually the property on Elgin Avenue because of the state, the condition of the property right now. But again, those are all issues related to the exemption only. So if we turn to page 1, the assessment summary is listed there on this page with the various properties. And Mr. Chairman, as you correctly pointed out, the supplementary assessment for 319 Elgin has now superseded what had been assessed under 4 separate roll numbers. It's just those 4 roll numbers combined. And so this afternoon we have the property at 275 Bannatyne, the property at 319 Elgin, the Patterson Global Foods Institute at 504 Main Street, the college's main campus, the large campus at 2055 Notre Dame Avenue, the Princess Street campus at 160 Princess Street, and the Stevenson campus at 2280 Saskatchewan Avenue. So those are the properties that are under discussion and review this afternoon. And the request that I'm making of this board is to grant these properties within the limits prescribed by the Act as exempt from liability for school taxes. So with that request in mind then, if we move to, initially the first several pages relate to the descriptions, brief descriptions of the properties. And I wanted to go through those briefly with the board to give you a sense of what we're talking about. Red River College, of course, is, it's got 3 distinct campuses right now with a total of 9 roll numbers, actually now reduced to 6 because of the Elgin amalgamation. Red River is, of course, the original and oldest college in the province with a full-time enrollment of over 12,000 students in 2018. That enrollment actually makes this college the 2nd largest post-secondary institution in Manitoba, second only, of course, to the University of Manitoba. So as far as the properties themselves, you've got on page 3, the Notre Dame campus. This is the very large, original and very largest campus by far. It's sitting on 98.7 acres of land and was established in 1963. The current portion you see at the bottom of page 3, there's actually 2 components: an institutional grant, which is the portion that we're going to be examining today, and then a small exempt portion, which we understand relates to the daycare. So the exempt portion of $67,000 is not under review this afternoon, and we have no issue with that. So that's the main campus. Then turning on to the next page, you can see the overhead map there with the main campus. Very, very large property, significant elements of greenfield still on it, but several buildings on it as well. The second component, or the second property in the portfolio of the college, is the Patterson Global Foods Institute at 504 Main Street. That's an original 10-story building, and the first 3 floors, first, second, and third floor, are used for the hospitality and culinary arts programs. The 4th through 10th floors are dormitories for the students. And important to note, Mr. Chairman, we are not again requesting a change to the dormitory component. That value for the dorms is $7.9 million, and that is not under dispute or debate this afternoon. It is strictly the what's shown. If you look at the top of page 5, what's shown is the institutional component of $9,479,000. And it's that component that we're requesting the school tax exemption should apply to. The bottom of page 5 is again the overhead showing the Patterson Global Foods property. Moving on to page 6, then 275 Bannatyne. That's actually just a parcel of land that is adjacent to 504 Main Street, effectively forms part of that campus, and the land area there is 12,224 square feet. And again, you can see the clip from the department's website showing grants in lieu with an assessed value of $300,000. Then moving to page 7, the 160 Princess Street. This is the Roblin Center, and it's an original 6-story building that was constructed in 1905, and then there were some additions built in the early 2000s, located on 1.4 acres of land. This has Red River's business, creative arts, and IT programs, and it's also got its downtown bookstore and library. And that campus is located at the corner of Princess and William. And again, the clip from the department's website indicates the assessed value of $32,961,000, and we're going to be requesting that that be school tax exempt as well. Moving on to page 8, then we've got the Stevenson campus at 2280 Saskatchewan Avenue. This is a campus dedicated to the college's aviation and aerospace program. The campus has got a building area of 51,860 square feet located on 7.6 acres of land. The college, we note, is a sub-lessee of the land from HMQ and the Winnipeg Airports Authority, as shown in the clip on page 8, where Red River is shown as lessee from HMQ. And again, the grant is shown at the bottom of page 8 with the value of $6,215,000. For reasons I'll get into, I'll actually be making a slight adjustment to that in terms of my request for an exemption. That's because of the limit, the prescribed limit under the legislation of the school tax exemption. So I'll explain that in a little bit further detail later. Page 9 indicates there's an overhead. The map just shows the entire WAA area, but of course 2280 Saskatchewan is just a small component within that area, and the aerial is shown on the bottom of page 9. Then finally, on page 10, we've got the Elgin Avenue property. So this is the property for which a supplementary assessment was issued, and there was a number of different parcels prior to the amalgamation by the department, and it's actually a construction site right now, and it's going to be the site of the college's new innovation center that is going to be opening up next year. So they're in process with that, and we expect that property or the improvements to be capable of occupancy in 2021. So that's the campuses we're talking about this afternoon, and fundamentally then going to page 11, what our request is this afternoon, Mr. Chairman, and I'm going to be quite blunt. Recall that in my earlier submission when we first convened this hearing, I suggested that the entire assessment structure is based upon principles of fairness and equity, and I'm going to be asking this board to validate those principles in making its decisions concerning the issues that we're going to examine this afternoon. And for the reasons that I'm going to bring forward, I'm suggesting that truly, in order to support that foundation, the college must be found to be exempt from school taxes. So on page 11, the section can't be read in isolation, but the section that is going to be in our submission applicable at the end of the day to the college is section 23.1 of the Municipal Assessment Act, which states that subject to sections 25 and 26, real property is exempt from taxation for school purposes where the real property, and then sub D, there's a few other subsections there, but sub D is what we're concerned with, is owned by or is held in trust for and is used by a college or seminary of learning to a maximum exemption of 1.62 hectares. Incidentally, for the board's reference, the 1.62 hectares relates or translates to an exemption of 4.0 acres, and my submissions will incorporate that limit. So what we're suggesting is that when one examines the entire legislative scheme, this section and section 22 can't be viewed in isolation, because there's a corresponding section under the Municipal Act that must be considered and that forms an integral part of the scheme. And when those are considered together, we submit in no uncertain terms that section 23 would certainly support the notion that the college should be exempt from school taxes. So then, going on to page 12, these are the core provisions of the legislative scheme that I am suggesting that the board must consider this afternoon. There are two sections of the Municipal Assessment Act, the one I just read and one further one that we'll talk about shortly, but also crucially, a section, two actual sections of the Municipal Act that must be considered together and must be read together. So the starting point is the Municipal Assessment Act, Section 22(1). That's the first section shown on page 12 that states that subject to sections 25 and 26, real property is exempt from taxation levied by a municipality other than for local improvements where the real property is owned or used by or held for use by a college as defined in Section 1 of the Advanced Education Administration Act. That's the first key section. The second key section is the one I just read, 23 sub 1, which of the Municipal Assessment Act, which says, again, subject to sections 25 and 26, real property is exempt from taxation for school purposes where the real property is owned by or is held in trust for and is used by a college or seminary of learning to a maximum exemption of 1.62 hectares. Now, crucially, the Municipal Act provisions that I'm going to ask this board to carefully consider, the core provisions are initially the definition of institutional lands, which means at the bottom of page 12, lands that are exempt from municipal taxation, owned or leased by the Crown, Manitoba Properties Inc., the University College of the North, or a college as defined in Section 1 of the Advanced Education Administration Act and used as the site of an educational institution. So that definition is of some import in this case as well. And then section 335, sub 1 and sub 3, they're both listed on page 12 and 13. Sub 1 states grants must be paid in each year to the municipality with respect to Crown lands or institutional lands, which is what we're talking about, in the municipality in lieu of the taxes that would be payable with respect to the lands if they were not exempt from municipal taxation. Similarly, section 335 sub 3, and this is now at the top of page 13, talks about the amount of the grant, and the amount payable as a grant under subsection 1 in respect of a property is the amount that would be payable as taxes under this part in respect of the property if it were not exempt from municipal taxation. Again, that term is used in sub 3. And what we're suggesting is when you read these provisions together, it becomes apparent in our submission that Red River was intended to be exempt from school taxes. There's clearly an intent to pay a grant, but one must also look at the provisions together and the intent of the legislature with respect to the school tax exemption and the use of the term college. And what we're suggesting is when one examines the history behind the ownership of Red River's properties, it becomes apparent why the scheme is structured the way it is. There are specific reasons for this structure that we're going to present this afternoon, and the case we're suggesting also involves several principles of statutory interpretation that are going to assist this board in interpreting these provisions. So I'm going to go through these briefly, the statutory interpretation principles that we believe would apply. The initial, at the middle to the bottom of page 13, there's something called the modern principle of statutory interpretation. And the court in the case that's listed there, Bon Secure, cited Justice Estes' comments where he stated, in Stubert, the court recognized that in the construction of taxation statutes, the law is not confined to a literal and virtually meaningless interpretation of the act where the words will support on a broader construction a conclusion which is workable and in harmony with the evident purposes of the act in question. Further down, Chief Justice Dixon in Bronfman Trust said, in light of this passage, there's no longer any doubt that the interpretation of tax legislation should be subject to the ordinary rules of construction. Dreger fittingly summarizes the basic principles as the words of an act are to be read in their entire context and in their grammatical and ordinary sense harmoniously with the scheme of the act, the object of the act, and the intent of Parliament. So one must examine, and I'm suggesting in our submission we do just that, what the intent of the legislature was in coming up with this structure. Top of page 14, the next page, that principle is codified in the Interpretation Act, which states that every act is to be given the fair, large, and liberal interpretation that best secures the attainment of the act's objects. Now, when you look at the, in this particular case, when you look at the structure of the legislative scheme, we're suggesting that it becomes clear that the term college, that's referred to in section 23, which is the school tax exemption section, must include Red River College in order to achieve the very purpose and intention of the legislature consistent with that modern principle. Conversely, we're suggesting that the alternative reading of section 23 would actually lead to an absurd result that frustrates the intention of the legislature. The presumed knowledge in the middle of page 14, the next principle that we touch on briefly is presumed knowledge, which is described as this. The legislature is presumed to know all that is necessary to produce rational and effective legislation. This presumption is very far-reaching. It credits the legislature with a vast body of knowledge referred to as legislative facts and with mastery of existing law, common law, as well as ordinary statute law and the case law interpreting statutes. The legislature is also presumed to have knowledge of practical affairs. It understands commercial practices and the functioning of public institutions, for example, and is familiar with the problems the legislation is meant to address. In short, the legislature is presumed to know whatever facts are relevant to the conception and operation of its legislation. That's going to be an important principle when we looked at the interplay between the Municipal Assessment Act and the Municipal Act. So then going further down, we've got a principle called coherence. And this, again, we suggest is fundamental to looking at the scheme this afternoon. The principle of coherence states that it's presumed that the provisions of legislation are meant to work together, both logically and teleologically as part of a functioning whole. The parts are presumed to fit together logically to form a rational, internally consistent framework. And because the framework has a purpose, the parts are also presumed to work together dynamically, each contributing something toward accomplishing the intended goal. The presumption of coherence is also expressed as a presumption against internal conflict. At the top of page 15, we also mention the next concept briefly called the approach to related legislation. Sullivan describes that concept as statutes enacted by a legislature that deal with the same subject are presumed to be drafted with one another in mind, so as to offer a coherent and consistent treatment of the subject. And then further down, the provisions of related legislation are read in the context of the others, and the presumptions of coherent and consistent expression apply as if the provisions of these statutes were part of a single act. Definitions in one statute are taken to apply in the others, and any purpose statements in the statutes are read together. And again, with this framework and what we're suggesting, that the two sections of the Municipal Assessment Act and the Municipal Act being read together, they form that logical, coherent framework. The consequences of the interpretation is sort of the last principle we talk about briefly at the bottom of page 15. What we're suggesting that if there's an interpretation that frustrates the legislative scheme, that would of course be considered absurd, or if it was inequitable. Again, Sullivan states such statutory interpretation is founded on the assumption that legislatures are rational and competent agents. They enact legislation to achieve a particular mix of purposes, and each provision in the act or regulation contributes to realizing those purposes in a specific way. An interpretation that would tend to frustrate legislative purpose or thwart the legislative scheme is likely to be labeled absurd. Now, further on, then there's a paragraph. I'll leave it with the board to read the next paragraph on page 15. But something I wanted to point specifically out at the top of page 16, and this is again out of Sullivan. Since it may be presumed that the legislature does not intend unjust or inequitable results to flow from its enactments, judicial interpretations should be adopted which avoid such results. And recall, Mr. Chairman, that is my suggestion this afternoon, to prevent precisely this unjust or inequitable result that flows from denying the college the school tax exemption. So now, moving on to the middle of page 16, the analysis of the scheme that we're talking about. So the first step 1 in this analysis, relates to the initial section 22 of the Municipal Assessment Act. That section of the Act, 22(1)(b)(1), actually exempts the college from municipal taxation, which is, I believe all parties agree, is the entire levy, the school division levy, the municipal levy, and the ESL levy, other than local improvements. And what 22(1)(b)(1) says is, subject to sections 25 and 26, real property is exempt from taxation levied by a municipality other than for local improvements where the property is owned or used by or held or for use by a college as defined in section 1 of the Advanced Education Administration Act. So we have to, of course, then determine, well, what's a college under the Advanced Education Administration Act? Then if you go to our page 17, and this is directly out of that act. It states, if you see under the definitions, college means Red River College and a college established under the Colleges Act. And so by definition, of course, the Red River College is such a body or is a college under the Advanced Education Administration Act, and therefore the section 22(1)(b)(1) would apply to this college. The only other college, coincidentally, I've put the reference in there, the only other college established under the Colleges Act is the Assiniboine Community College, and those are located at pages 17 and 18. So, having established that the college is in fact exempt from municipal taxation under 22(1)(b)(1), that is the first step in this process. But what you can't just stop with that. Of course, you have to move on to the sections, because at the end of the day, the college is in fact still paying grants in lieu of taxes. And so I'm going to skip to page 19 now. The question comes up, and it's an important, this is an important consideration or point of detail in the submission. The initial taxable status of Red River is an entity that's fully exempt. At the time that this legislation was passed, in 2015, there was actually a change in the legal ownership of the main campus. But when this legislation was passed, the property was actually owned by HMQ. It was owned by the province. So legally, there is no way it is not legal for a municipality to tax provincial or federal lands. It simply cannot be done. So it makes perfect sense that when the starting point in the legislative scheme is Red River's property would be entirely exempt under Section 22 because by virtue of the ownership. And that we're suggesting is fundamentally the rationale and the purpose for this initial section, and this initial section only, Section 22, it's because it could not be otherwise. It would not be legal to tax property held by HMQ by the City of Winnipeg. So then, having established that, we go to sections 334 and 335 of the Municipal Act. This second step, this involves a review of the provisions in the Municipal Act to establish the authority for the payment of the grants in lieu. As mentioned, the ownership of Red River's properties and the property on the Notre Dame campus has in recent years been transferred to the Board of Governors of Red River College, having formerly been owned by HMQ. But in order to understand the provisions under the Municipal Act, one must consider what the intent, you have to look at what the intent of the grants in lieu structure is. Why do the federal and provincial governments and the respective agencies pay any property taxes at all when they're not required to do so? Simple reply to that question, and actually this is taken from the federal government's payments in lieu of taxes, but would apply equally to the provincial grants in lieu of taxes. So at the bottom of page 19, the first part of the clip about the payments in lieu of taxes program, Public Services and Procurement Canada administers the payments in lieu of taxes program. The department distributes more than $560 million for approximately 17,000 federal properties under the responsibility of over 1,100 taxing authorities across the country. And then if one goes further onto page 20, the key program features. And I'm going to ask the board, keep this in mind, because this is precisely part of the rationale for the structure. The payments are based on the principle of fairness, respecting both the taxing authorities and the federal government, and in our case, the provincial government and its agency, Red River College. They are equitable in comparison to those made by other property owners. They're equitable compared to those payments made by other property owners. That is conceptually key in this debate. Payments are calculated on the basis of values and rates which would apply to federal property if it were taxable. Payments respecting the property tax due dates are established by taxing authorities, and then of course the Government of Canada receives equal access to services provided to other property owners by the municipality. So what the federal government and the province and Red River College, by virtue of the provisions in the Municipal Act, are saying is, okay, we are citizens in this municipality, we are benefiting from municipal services, and we agree to pay our fair share. That's what the key program features in the PILT program are, that's what the key features of the grants in lieu program would be as well. So then when one looks in that context, and now I'm on our page 21, then if you look at the provisions of the Municipal Act now, and this is what codifies the obligation to pay grants in lieu. So under section 334, we've got some definitions. Crown, of course, means HMQ and Right of Manitoba, which is the entity that held the Notre Dame campus originally. Crown lands means lands that are vested in the Crown and includes lands referred to as provincial lands. And for our purposes this afternoon, institutional lands means lands that are exempt from municipal taxation. That's an important term. Owned or leased by the Crown, Manitoba Properties, University College of the North, or colleges defined in Section 1 of the Advanced Education Administration Act. Recall that Red River is such a college, it is so defined, and used as the site of an educational institution. And then Section 335 sub 1, grants must be paid in each year to municipality with respect to Crown lands or institutional lands in the municipality in lieu of the taxes that would be payable with respect to the lands if they were not exempt from municipal taxation. And then Section 335 sub 3, which speaks to the amount of the grant that's to be paid. So the amount payable as a grant under subsection 1 in respect of a property is the amount that would be payable as taxes under this part in respect of the property if it were not exempt from municipal taxation. And fundamentally, Mr. Chairman, what I'm suggesting is this section removes the properties of the college from the operation of section 22. That's the section that relieves or that exempts the property from municipal taxation. And this is the section that says, notwithstanding that we are exempt because we are the initially HMQ and now the body that is initially exempt, we're agreeing to pay a grant as if we were not exempt under section 22. Municipal taxation, see the term, refer to the term municipal taxation, which is what section 22 is referring to. Section 22 says exempt from taxation levied by a municipality, and I'm suggesting that has the same meaning as if it were not exempt from municipal taxation. So now we've removed the properties from the operation of section 22. And this is where the debate, I don't think anything I've said so far would create a lot of stir as between the perspective of Altus Group and the perspective of the City of Winnipeg. Here's where we diverge though. This is the point at which we completely diverge. We're suggesting that the objective of the legislature, and I'm on page 22 now, the objective of the legislature is put into plain view, I'm suggesting, when one considers the wording of sections 335.1 and particularly 335 sub 3. Both of these sections state that grants are to be paid based on the amount that would be payable if the property were not exempt from municipal taxation in the first place. The use of that phrase is the reference to section 22, and that is the structure and the connection between the two sections, recognizing the fact that the starting point for Crown and institutional land is that it's not taxable at all. So the entire scheme we're suggesting then is with those two intricately related sections as the starting point. The third and final step is where we diverge, and that what the issue and the question to be determined is this: okay, we've now taken all of these properties by virtue of their ownership, by virtue of this legislative structure, we've taken them out of the operation of section 22, but you can't stop there. You then have to look at what other sections, if any, apply to the properties under consideration in the Municipal Assessment Act. And that's where we diverge, and that's where we're suggesting section 23 comes into play. So having established that the grants in lieu are to be based upon the taxes that would be payable if the property wasn't exempt under 22, what, if any, sections apply? And of course, what we're suggesting is section 23 comes into full view then and has to be considered. Section 23 states that subjects to 25 and 26, real property is exempt from taxation for school purposes where the real property is owned by or is held or in trust for and is used by a college or seminary of learning to a maximum exemption of 1.62 hectares. That section you can see that section in operation with a couple of other colleges in the city. On page 23, we note that Herzing College at 1700 Portage Avenue is shown as school tax exempt, and properly so. They're one of the established colleges in the city, and the operation of the section is evident there, and as well it should be. And then on page 24, Robertson College. It was formerly located at 35 King Street, now located at 180 Main Street, and it is also school tax exempt, and again, properly so. It's a college. So on page 25 now, a plain reading, and now we're focused on section 23, 23(1)(d). So the grants in lieu for Red River's properties we're suggesting must be calculated based on the exemption for school taxes. It's in this way and in this way only that Red River's properties will receive the same tax treatment as the properties owned by other colleges. In order to give effect to what we're suggesting is clear and unambiguous provisions of 334 and 335 of the Municipal Act, the exemption from school taxes must be granted, because if they're not, of course, the grants paid by Red River would not be equal to the amount that would be payable if the property was not exempt under section 22. Now all of a sudden you've got a situation that where Red River's properties would not have the same tax treatment, and the entire foundation, the entire structure falls apart. The PILT payments and the GILT payments are based upon the premise we're not obliged to pay taxes at all, but we're going to as responsible citizens, but it has to be based upon principles of it has to be fair. Looking further, looking at the provisions in the Act, that theme of fairness resonates with section 335. What taxes would be paid if you are not entirely exempt under 22? Because we're obliging ourselves to pay taxes, but we're not obliging ourselves to pay taxes at twice the rate of every other similar institution in the province. It makes no sense. As we mentioned earlier, the principles of coherence and the treatment of related legislation we're suggesting has direct application here. The legislation is to be read as an integrated whole in order to arrive at a conclusion that favors harmony and equity. The interpretation we're suggesting does just that. There's an initial recognition of the fact that the province, HMQ, and subsequently through the definition of institutional property, Red River College is fully exempt due to its ownership. That recognition, though, is provided by section 22. Notwithstanding the fully exempt status of Red River's properties, the province and Red River are mandated to pay grants in lieu of taxes in the amount that would be payable if it were not exempt from municipal taxation under section 22 of the Municipal Assessment Act. That's section 335. Having removed the property from section 22, the remaining question is, what is the tax treatment provided to properties owned by colleges under the Municipal Assessment Act, which treatment is then used to establish the amount of the grants in lieu, because that's what section 335 is obliging the parties to do, we suggest. And the answer on that last point we're suggesting is clear. 23(1)(d) states that real property is exempt from school taxes where the property is owned by and is used by a college. That is the process we're suggesting that must be followed. The properties are owned by a college and used by a college. The multi-step analysis treats the legislative provisions as a cohesive whole and favors harmony among the provisions. And we're suggesting that the intent of the legislature becomes apparent through the analysis once and full effect is given to the clear wording in 335 of the Municipal Act. Now, if one looks at the alternative and the approach that's to date been favored by the city, we're suggesting that 335(1) and 3 become meaningless because Red River is paying property taxes that are in excess. It's not taxes that are at the level that would be paid if they weren't exempt. They are actually in excess of that. So because they're exempt, they're being asked to pay taxes that are more than twice the rate of tax paid by other colleges, paid by the very same post-secondary institutions in the province. And I'm on page 26 now, and in order to find that section 23(1)D of the Municipal Assessment Act now should not apply to Red River College, one would somehow have to interpret the word college. And the word college, it's very clear in that section. The word college in that section as not including Red River College. The oldest, largest college in the province, what the city's asking you to do is to say, well, Red River is not a college under section 23. With respect, absolutely they are. They could not be otherwise. And that's where one has to look at the entire structure to understand the interplay between section 22, section 335, and section 23. There's, again, one of the leading commentaries on statutory interpretation. Sullivan's commented on what ordinary meaning, and I'm suggesting the ordinary meaning of college would absolutely and have to include Red River. And Sullivan comments on what ordinary meaning means, and it's the expression ordinary meaning is much used in statutory interpretation, but not in a consistent way. Sometimes it's identified with dictionary meaning, sometimes with literal meaning, and sometimes with a meaning derived from reading words in their literary context. Most often, however, ordinary meaning refers to the reader's first impression meaning, the understanding that spontaneously comes to mind when words are read in their immediate context. The natural meaning which appears when the provision is simply read through, and what we're suggesting is that any common sense reading of college would by definition include Red River College. Now, the conclusion, and this is at the bottom of page 26 now, the conclusion that we've of course come to is that by virtue of this legislative scheme and by virtue of the clear wording of section 335 of the Municipal Act determining the amount of grants to be paid, when one looks at the entire intent and structure of the Gilt and Pilt program, resting on fairness and equity as the assessment system does, then one must find that one cannot stop at reading section 22 and section 335 and then come to a full stop. That is not doing this in either the system or the intent of the grants and Pilt program justice. So we're suggesting the school tax exemption must apply. Now, on page 27, there's a couple of wrinkles. I mentioned earlier on, there's a couple of wrinkles in this, or not wrinkles, but peculiarities in this portfolio that needed to be discussed. The limit of the exemption, as I've mentioned, is 4 acres under section 23. And if you recall, Mr. Chairman, the size of the main campus at Notre Dame was over 90 acres. So I'm going to be dealing with that particular issue with a separate document that we submitted. And I'd like to thank Mr. Dupuis and Mr. Valderrama for providing some of the cost details on the improvements on that site that weren't available through the assessor's website. So I appreciate that. Then we've got, though, the Elgin Avenue property, and that's the one that the case where the 4 properties had been amalgamated into one. So this is a separate issue for the board to consider in addition to what I've just submitted relating to the school tax exemption, because the Elgin Avenue property is a construction, or a site is a construction site right now. The building is not capable of occupancy. It's going to be coming online next year. But so the key question for Elgin Avenue is, can the property be considered to be used by a college? Because a requirement under section 23 is that it be owned by, but also used by a college in order to attract the school tax exemption. So that is an issue. What we're suggesting is that there is, if it's a construction site that's clearly dedicated to the college and to constructing the improvements that will be used exclusively by the college, then what we're suggesting is that is sufficient to be used by a college for the purposes of the exemption. But that's a decision I'll leave with this board, because that's the situation there is not as straightforward in our submission as obviously the rest of the campuses where the improvements are there and are being actively run as colleges day in and day out. That one has yet to come online, but I'll leave that for the board to consider. The Notre Dame campus I'll get to shortly, but there's also, I'm going to find that reference at the bottom of page 27. The other consideration, the other property that has to be examined a little more closely is the Stevenson campus at 2280 Saskatchewan Avenue. That's because in that case, the acreage is 7.6 acres. So the 7.6 acres is in excess of the 4-acre limit. At page 28, we've provided the income valuation for that property, showing the $6,215,000. Now, of course, properly so, there's no adjustment for excess land in that case, and there doesn't need to be, but for the purposes of the exemption discussion and due to the 4-acre limit, there would need to be an adjustment. Pardon me. So at the top of page 29, the full exemption would apply to the building and land, but since the statutory limit for the school tax exemption is 4 acres, we're applying a land value of $500,000 for the land area of 3.6 acres that exceeds the limit. And so the request for Saskatchewan Avenue, to be clear, would be that the school tax exemption would apply to a value of $5,715,000, with the assessment of $500,000 remaining as fully grantable or fully taxable. And so for those reasons, we're asking for the school tax exemption to be applied in that manner. Now, the one additional, the property that requires a bit of additional examination is 2055 Notre Dame Avenue. So if I could ask Mr. Chairman, the board members of the city to refer to the brief. It's a brief 18-page supplementary document that is relates to 2055 Notre Dame Avenue only. And with the 4-acre limitation, what we've done is, with the details of the assessments of the improvements, what we've done at the bottom of page 2, there's the main floor area that adds up based upon the calculations done on page 2 to 174,240 feet, which is 4 acres. The assessments based upon those areas and the assessments that are associated with those areas is 28,944,853, and then adding 4 acres of land to that value results in a total exemption request based upon the 4-acre limit of 29,273,000. So we are asking for based upon the 4-acre limit for the school tax exemption to apply to $29,273,000 of the much larger assessment for that campus. And I would be very pleased to answer any questions that may have arisen from this submission. Thank you.
Thank you, Mr. Reimer. Mr. Valderrama or Ms. Bomback, who would like to go first?
I am certainly happy to go first, and then if Mr. Valderrama has any further questions, perhaps would that be agreeable in terms of an order, Mr. Chair?
Certainly.
Okay. Thank you for that, Mr. Reimer. I just wanted to clarify a few points in relation to the argument that your client is putting forward. Firstly, I just want to confirm that your client does not dispute that it currently is exempt from both municipal and school taxes under Section 22 of the Municipal Assessment Act?
It does not dispute that, no.
Okay, thank you. And you accept that it is an institution that is defined in the Advanced Education Administration Act. You agree with that?
Yeah, absolutely. It's a college under that act, yes.
All right, thank you. And just to confirm the balance of your position, is it correct that your client is taking the position that essentially, if Section 22 essentially doesn't apply anymore for grant calculation purposes, then the college would fall under section 23. And essentially, it would therefore be exempt from school taxes, so the amount of any grant would be equivalent to municipal taxes. Is that a fair statement of what your client's position is?
Yes, mathematically, indeed, it would be grants that would be payable to the equivalent of the municipal taxes.
Okay, thank you. You mentioned a couple colleges that are captured by Section 23 of the Municipal Assessment Act, and in particular, Herzing College and Robertson College. Do you have any reason to dispute that neither of those colleges are founded or otherwise constituted by provincial legislation?
Oh, no, they're private colleges, absolutely.
Okay, so you'll agree that they're not subject to any kind of provincial oversight?
I'm not sure I would agree with that, but I would agree that they don't have provincial funding. I would still think there's educational standards as being members of the post-secondary system that they have to comply with, but certainly they don't receive independent provincial funding as far as I'm aware.
Okay.
If that's what the question is.
That is, yes, thank you. And my last set of questions then for you, Mr. Reimer, as it relates to Red River College, would you agree that Red River College is indeed a creature of statute?
It is indeed. Red River College Act, now formerly under the Colleges Act, yes.
Okay, and under the Red River College Act, the board of Red River College is in fact appointed by the Lieutenant Governor and Council?
Yes. Yeah.
Thank you. And it is subject to provincial oversight?
It is subject to the oversight of the minister, yes.
Okay, and at present, does Red River College receive provincial funding?
Yes.
Okay. Those would be my questions, subject to any questions Mr. Valderrama may have, or Mr. Chair or any of the other panel members.
Mr. Valderrama, do you have questions?
I have no additional questions, Mr. Chair. I think Ms. Bombach captured everything.
Then I will turn to Mr. McIntyre.
I have no questions.
Ms. Nesbitt?
I think I have questions, but I don't know if I should wait until after the city's presentation. Maybe I'll just sort of start by how I see the scheme of these exemption provisions, that there is sort of a overarching scheme to it. The first provision, section 21, which we have not talked about, there is no taxes. It's an exemption from all taxes, including local improvement levies, very specifically named. The next,
You're asking Mr. Reimer to confirm
I'm
this?
just
Is that
put
what you're
a
doing?
little bit of a preamble here.
Okay.
And then under 22.1, there's specific properties that are identified and specifically referenced that have an exemption from municipal and school taxes levied by a municipality. And then finally, section 23, school taxes only. So do you see, your argument is that Red River College falls under two separate exemption provisions. Is that right?
Red River College, it's almost right.
Well, under 22.1, it's specifically named.
Yeah, yeah.
And then you're saying, but it also, 23 also applies.
It absolutely, but that's the intervening section. Section 335 is the linkage between the two sections in the Municipal Assessment Act. Because if you recall the statutory interpretation provisions, the coherence, the principles of harmonious interpretation, without section 335 of the Municipal Act,
Yes.
the two sections don't make any sense. And without 335 of the Municipal Act, Red River College would be paying zero taxes, because then they're fully exempt under section 22.
Yes.
So I completely agree that there are two sections that apply to colleges. One is very narrowly stated in section 22. It's a very specific subset of colleges. Section 23 talks about just the word colleges, which is much broader in my submission.
Yes.
The reason that there's two sections, so I guess absolutely I agree that there's two sections that apply, but it's because of the intervening requirement by 335, that one has to take the final step to section 23.
Okay,
So-
then, so if I can just follow up on what you're saying from the Municipal Act,
Yes,
Red River College is exempt from tax
under 22, yep,
under 22(1), or
yep,
that
yep,
section, 22.
Yep.
It moves then to the Municipal Act where a grant is established,
exactly.
right?
Yes,
So therefore, am I correct in reading, it's no longer taxable, it is now grantable? Is there a section in the act that says, notwithstanding that a grant is paid, you're now exempt from taxation again?
yes, there is.
Where is that?
335 sub 3. That's exactly the point, Ms. Nesbitt, I'm suggesting of 335 sub 3.
But
The wording,
I have a different understanding of that section. It says to me, and maybe we have a different understanding, and you could perhaps clarify then that you're seeing it differently.
yeah,
What 335 does is establish the tax that's payable, right? So the exemption is under 22. It's exempt from municipal and school tax. Notwithstanding that, we're going to pay a grant under 335.3, equivalent to municipal and school tax, because that's what the original exemption was.
not quite, with respect.
not how
That's why
not
the
how
wording,
Reading it.
exactly. So that's why the wording,
Uh-huh.
if one turns to, and I'm going to be at the, I don't know, you know what, let's go to the attachments. So on our main brief now, the very, very long brief.
Yep.
If we go to page, page 59, please.
I'm sorry, you'll have to give me a minute here to
Certainly.
find a document that has 59 pages.
No, yeah. It's the larger brief, yeah.
Ah, okay, all right, got it.
So 59, and Ms. Nesbitt, I really appreciate the question, because without this, if one isn't going to give effect to the wording, or is interpreting the wording in 335 in a different way, the entire structure I'm suggesting isn't coherent anymore. But the key being, when one looks at Division 7, this is the division that's obliging what amounts to a payment by the provincial government at pleasure. So it's saying we're not legally obliged to, but we're going to make these payments to municipalities, but it has to be based upon the framework on 335. And then specifically, if one goes to the top of page 60, and this is the very same section that Ms. Nesbitt that you're referring to, this is talking about the amount of the grant.
Right.
So the amount payable as a grant is the amount that would be payable as taxes under this part in respect of the property if it were not exempt from municipal taxation. And recall that my suggestion that section 22 does talk about exemptions, an exemption from payment of taxes levied by a municipality other than for local improvements. And that's where I'm suggesting this is stage 2, part 2 of the 3-stage test. So you've pulled it out of section 22, but that doesn't mean you can't look at the rest of the act and say, okay, but is there another section that applies? And the only way you can find that it doesn't is by saying that Red River isn't a college under section 23. Here's a couple of examples of that very process. If we could, in that same brief now, if we could go back to page 3. On page 3 of that brief, recall this is the main campus. And so you've got the grantable portion of 64,542,000. So that's the 98 acres and every part of the improvements except for the daycare. That's the exempt component of 67,000. But think about that. So what the department's done, properly so, I suggest you, this is precisely it. What they've properly done is they've said, okay, section 22, you don't have to pay, like you're exempt from taxes, but 335 of the Municipal Act says you'll pay grants in lieu as if you weren't exempt. Okay, But then you have to look at what else applies. Well, guess what? There's a daycare in there, and daycares are exempt under a different section again, and it's section 22. I'll just give you the page number reference if you want to look it up, but you need not turn to that page number. It is section 22. Daycare. Oh, it's 22 sub 1 sub K is used primarily as a nonprofit daycare center. So the department there has properly, I suggest, said, okay, if the property weren't exempt, is there anything else in the act that would apply that would still grant it a different taxable status? In the case of the main campus, yes, there's a daycare. That's correct. They've used that third step. If you then go to page 5, and this is again the Patterson Global Foods Institute, this is the campus where you've got the first 3 floors of that's culinary arts, and that's the component under discussion this afternoon. The residential 2 component, though, that's the dormitories. Don't forget, that's the floors 4 through 10. But again, okay, so 504 Main Street, the starting point is section 22. It's fully exempt except for local improvements. Now you go to 335. Okay, so 335, you'll pay taxes as if you weren't exempt from municipal taxation. But then the critical final step is there something else in the act or in the legislative regime that would apply? And in this case, properly so. The department has put a $7.9 million assessment on the dormitories because that is a separate part of the act that applies. And that's the very third step that I'm suggesting has to be done in this case with the school tax exemptions. So the very thing that I'm suggesting has already been done in two ways relating to different sections, but it's the very same process where the stopping point isn't 335 full stop, everything's grantable. The stopping point is the third step. The second step is an intermediate step saying, okay, we're volunteering to pay our fair share, which is what these programs are based on. But in order to calculate that fair share, as if it were not exempt from municipal taxation, are there other public policy decisions that have been made that would place this institution in a different framework than fully taxable? And the answer we suggest is a resounding yes, because they're a college. They're a college under section 23.
So for clarity purposes, just in terms of section 23, I note that college is not specifically stated to include anything under the Advanced Education Act.
Correct. Correct.
So, but it's very clearly stated in section 22. So
it is indeed.
Believe the lack of that section or reference in section 23 is an oversight? It was meant to include it?
It's not an oversight at all with respect. I'm suggesting that section 23 is the much broader, it's the plain common sense understanding of college. Section 22, recall, Ms. Nesbitt, section 22 and those exemptions, 22.1 and the exemptions we're talking about are there for a specific purpose because they are crown properties or institutional properties. So that part of the structure is very, very specific, which is why the college in section 22 is only the college under the Advanced Education Administration Act and Assiniboine College under the Colleges Act. Very, very specific subset, but that's because of the structure. The more general definition, which is the much larger set of which the 2 colleges, Red River and Assiniboine, are a peculiar subset for specific reasons, but they still form part of the larger set in section 23. What section 3 doesn't say is, you know, the school tax exemption for a college other than a college referred to in section 22 or you know, wording to that effect. I'm suggesting the college in section, the term college in section 23 is actually the broader term so that it can capture both Red River College and colleges like Robertson College and Herzing College. Okay,
this scheme has been in place for many years now.
It has.
With minimal amendments to the legislation. Why hasn't it been challenged before? Why now?
I cannot answer that question. I'm taking a position that I believe is extremely fair, logical, and equitable. I cannot comment on why it wasn't perhaps debated sooner. I think it's a very good question, and I don't think that I'm going to suggest that no inference should be made from that. And I'm asking the board to consider the submissions this afternoon, but it is a fair question.
And my final question is, do you know any other property in the province of Manitoba that could claim an exemption under both section 22 and section 23?
Well, if there are other Crown properties that an exemption, no. But again, if we're talking about the structure where you have to consider the interplay between 22 and 335 and section 23 or other provisions of the Act, that's exactly the examples I just gave you, where with the main campus, with the daycare exemption, and with the Patterson Global Foods, with the dormitory classification, that's exactly the process that's been done. It's the very same process. It's pointing to different sections for good reason, but it's the very, very same process.
And it's pointing to different uses as well, right? Like,
well, certainly, yes. Yeah, absolutely.
That's why I see it being slightly different, split out on the roll that way.
Yeah. I understand the point. I guess at the end of the day, Ms. Nesbitt, I'd suggest certainly that college in section 23 is absolutely meant to be the larger set of college properties versus 22 being there for the specific reason being of a specific subset.
Okay.
Thank you for those questions.
And thank you, Mr. Reimer.
Yeah, I have some questions. You began your brief with explanation of some of the principles of statutory interpretation. A couple of other considerations I'd like to ask you about. The provision in section 23 about seminaries of learning colleges, the reference there, do you know, did that predate the references in the Act made about Red River College specifically? Which came first in the scheme of things? Because it strikes me that one has to know that, and also in order to interpret the legislation. Like, was something else following because the initial thing did not serve fully a new purpose? You know, that sort of thing.
Well,
which is the chicken, which is the egg here?
No, I think they're contemporaneous, but what's changed is this, Mr. Chairman. Recall that when the college initially started out with just the 2055 Notre Dame campus, the main campus. And recall as well that the campus at the time, up until 2015, the campus was held by HMQ, was held by the province. So in terms of the context, that was changed when the Red River College Act was passed and basically title transferred from HMQ to the Board of Governors of the college. But the structure, and that's key to underpinning this structure, that's why I'm suggesting submitting this afternoon that the structure is the way it is. Sections 22 and 23 were contemporaneous, but they were meant to work together in the context of 335.
So are you saying that those provisions were adopted at the same time? Red River College appeared in the 1960s. Was the reference to colleges and seminaries of learning also inserted into the Assessment Act in the 1960s at the same time?
No. The Municipal Assessment Act, I believe this was redrafted well after the 60s. But what I'm suggesting, if I understood the question correctly, you're asking about the interplay of sections 22 and 23?
No, I'm asking which came first. Was one an elaboration on the other because there was a difference in time as to when those sections were adopted?
Sorry, but again, as between 22 and 23, or as between 22, 335 and 23?
I'm not considering 335 at this point.
Okay.
There is a relationship in the Act between 22 and 23 because both reference colleges.
Yep.
One is a very general reference, the one in 23.
Yes.
The one in 22 is more specific.
Indeed.
What was the difference in time when those two provisions were adopted?
I don't, as far as I'm aware, Mr. Chairman, those were adopted at the same time. That was between 22 and 23.
Okay. Next question, I guess, is there any principle in statutory interpretation relating to the specific and the general? Does the general reference trump specific, or does specific trump general?
Certainly my suggestion in this case is that the reference to college in 23 as the general reference includes the subset, the more specific subset in section 22. Otherwise, as I mentioned, Mr. Chairman, otherwise you have to read section 23 and the word college as not including Red River College. And again, this, I think this goes further, just to answer that, this goes further to Ms. Nesbitt's question. If section 23 was meant to exclude, and again, as I've stated, I think 335 is the linchpin to this. But if you look at section 23 and it was intended to exclude Red River College, I'm suggesting that should have been put in very specifically. Exempt from school taxes for a college other than a college defined under the Advanced Education Administration Act, or taking out what plainly otherwise is a college from the word college. Without taking it out, I can't imagine that it shouldn't be included as the oldest and largest college in Manitoba.
Okay, so you're saying both 22 and 23 apply? I asked that because it seems that I heard you say the application of 335 then results in 22 disappearing. It no longer applies to.
Absolutely, and that's.
I don't understand. Yes. I don't understand that disappearance.
Okay.
How is it that there can be the application of 335 if there isn't in the background the application of 22?
So, if one goes, in order to understand the structure again, if one goes to, and I'm trying to find the page reference. Okay, so Mr. Chairman, if I could ask you to turn to page 19 of our, this is again the big brief, the main brief. So recall that the college initially, the campus at the time that this legislation was passed, the Municipal Assessment Act, 2055 Notre Dame was the only campus.
Okay, what time are you referring to there?
Well, this would have been in the early, I mean, for my purposes, in the early 2000s. That's as far back as my tax searches went. But HMQ, put it this way, HMQ owned the property up until 2015. Okay, so and these sections have not been amended since 2015. So the HMQ, by definition of its ownership, it is illegal for the city to tax it. It cannot tax it. It's simply illegal and not permitted. So when one looks at the structure, and this gets to the very heart of how can two different exemption sections apply to the same entity, it's because of the structure involving 335. 335 says, so you start out from a position where you're not taxable. Okay, so section 22. Section 22.1 is codifying or is confirming the fact that it's not taxable. It's fully exempt. It couldn't be otherwise, but that's what that section, that's the effect of the operation of that section. But then recall, and I'm now, you don't need to turn there, but I'm now back on my page 21 at the bottom. This is the key under the Municipal Act, the amount of the grant. The amount of the grant is payable as taxes in respect of the property, and these are the key words, if it were not exempt from municipal taxation. If it were not exempt from municipal taxation. So what this legislation is saying is, okay, let's create a fiction. The initial fiction, or the initial exemption section is section 22, which is merely saying you're fully exempt other than local improvements, but the reason for that is you weren't taxable in the first place. But what section 335.3 is then saying is, we're going to create a fiction, and there's a reason for it. Now we've got a property that's not exempt. Okay, if it were not exempt from taxation, that's section 22. If it were not exempt from municipal taxation, and recall, I'm defining or I'm suggesting municipal taxation is the very thing that section 22 refers to. So it's saying what would the taxes be if our campus at 160 Notre Dame wasn't exempt from municipal taxation and wasn't exempt from municipal taxation pulling out of 22? Okay, now you have, as I've said and as you alluded to, now you have created this fiction that relates to section 22 because you have to calculate fair payments in lieu of taxes. In order to calculate the fair payment in lieu of taxes, you still have to look at the operation of the Municipal Assessment Act as it applies to that property, whether it's daycare, whether it's dorm, whether it's another exempt use, including as a college. Mr. Chairman, and this is the key, recall that and I won't go back specifically to it, but the key program features that I've included, this is from the federal government, but the very same, of course, would apply to the provinces. We're going to pay our taxes and it's at our pleasure, but we're going to do it, but it has to be a fair share. And to ask the college to pay for at a rate that's double that is not a fair share.
So are you saying that both those sections should be seen as being in the background when 335 is applied? The section 22 provision and the section 23. They're both in the background. Is that what you're saying?
No, not at all. Actually, it's switching the last two parameters. Section 22 is first. Section 335 then is the second. Those two, effectively, that's what creates the fiction of taking section 22 out of the picture. And then
how can it be out of the picture? Because it would not be grantable if it was not in the picture. That's the point I'm not understanding.
But the wording in respect of the property, if it were not exempt from municipal taxation, that's the reference to section 22.
Correct.
But if it were not exempt from, so forget about section 22 now, like just temporarily, because I'm saying that's the fiction. So I walk up to this building at 160 Princess Street, and I see the name Red River College, and I go in and I see there's a college bookstore, and I see that there's classrooms, and I see that there's lecturers teaching, and I conclude this is a college. So I go back to the Municipal Assessment Act, and I say, well, I wonder what the taxable status of it is. And lo and behold, section 23 says it's exempt from school taxes. Similarly, I go down the street and I go into Robertson College, very same post-secondary institution in terms of the function that it fulfills. It's a private institution, and there's no debate about that. I believe that's irrelevant. It's another college. I see a bookstore. I see lecture halls. I see what's happening. It's the very same thing. So the suggestion that the college, because it's a public college, and recall my comments at the outset of this hearing, the absurdity of the position I'm suggesting, where you're saying, or not you're saying, but the city is saying, okay, you're exempt under section 22, but because you're exempt, you're going to pay taxes at almost 3 times the rate of private colleges. Just think about that. You're asking a public college to pay taxes at 3 times the rate of a private college because they're exempt. That cannot be, that is in just my respectful submission, not in any way consistent with the intent of the PILT program or the grants in lieu of taxes program at all. And it just exemplifies the very thing I'm talking about. So I guess to get back to your original question, section 22, which operates in the background, is you go from 22 to 335, and that's what has the effect of saying, where one has to stop and say, okay, 335 is saying we'll pay a grant, but what is the amount that would be payable if it were not exempt from municipal taxation? And that's the reference I respectfully submit to section 22. Then those two sections, that's where the fiction is created. And then you have to look at the asset that you've got and say, okay, what do I have here now? In the case of 504 Main Street, I've got 6 floors of dorms. Well, that's going to be residential too. So that's a different component of the act. And the distinction I'm suggesting, that there's no distinction between making that proper adjustment or that taking into consideration the proper different sections of the act and the regulations to come up with a dormitory versus taking a look at the different sections of the Act that relate to exemptions. That's a distinction without a difference, I'm suggesting, in no uncertain terms. You're looking at which other provisions of the Act and the legislative scheme apply to the college outside of Section 22, and I'm suggesting that's what 335 mandates you to do.
With respect to the colleges that are addressed in Section 22, is there anything about the manner in which the province not only has legislated the taxation of them, but also provides grants to them that should be taken into account in reading the Act and seeing what was intended by the legislature?
So there is provision, and I don't recall a specific section, which says that the province shall consider the obligation to pay property taxes when it's part of a much larger calculation. But the short answer is yes, it's taken into account. But I'm going to suggest this. If you recall, and I'd done a fair bit of research on this recently. If you recall back in, I think it was 2002, the province, with respect to the universities, University of Manitoba and University of Winnipeg, they amended the classification regulation to add a category called designated higher education property. In that, the effect of that amendment, and it was met with a lot of press at the time, both positive and negative. The effect of that amendment was to take the portioning from, I believe it was at 65%, take it down to zero for virtually everything, all university property except for dormitories. At the time, the Dewar government and the ministers were very, very clear that notwithstanding the very same section that the sections that I'm referring to that talk about the government taking into account liability for property taxes on the grants, the very same sections applied to the university at the time. So in theory, if the portioning was down to zero and the university suddenly freed up a bunch of cash, then the government should have been adjusting the operating grants down. And Minister McGifford at that time made very, very, very clear statements saying the intention of this is to free up funds for the universities and to make the tax treatment equitable with other universities in other provinces, and we will not adjust the operating grants. So notwithstanding that section is there, and it's a very good question, that section is there. That section, the actions of the government in the context of what happened in the early 2000s was that the impact of the property taxes did not result in a deduction or a reduction in operating grants. And so, again, with that sort of as a backdrop, I'm suggesting that consideration would not have a bearing on this discussion based on the precedent that was set in that case. But a very good question.
My last question is with respect to Section 335 of the Municipal Act. Were subsections 1 and 3 adopted at the same time, or did 3 follow 1 as a clarification?
I don't know. I thought they were at the same time. I mean, I can, I can look at this very quickly online if you'd like. I don't know the answer to the question without looking. Like I can go into the.
All right, why not? Yeah, could you?
Okay. Let me look that up right now. So it appears, Mr. Chairman, if you recall, there's different sort of footnotes in the different section. Okay, so 335 sub 1 and 335 sub 3 do not have a footnote, so it would imply that they were enacted at the same time. There's no separate amendment. Yeah.
That is all my questions. So we will turn to, would it be Ms. Bombach at this point, as opposed to Mr. Valderrama?
Yes, but I will ultimately leave that up to the Board of Revision. I'll be speaking just primarily to the legal issues respecting this grant matter that Mr. Reimer has been speaking to. And as far as calculations and factual pieces are concerned, I'll be deferring to Mr. Valderrama. So I'll leave it up to the board, whoever you wish to hear from first. But prior to that, I was wondering if we might be able to have a brief 5-10 minute recess. Would that be an option, please?
That's certainly an option. Yes,
Okay.
we'll take 10 and resume.
Thank you.
Thank you.
Thank you.
Okay, we're live.
All right. Ms. Bomback, are you there?
Oh.
No.
Nope. And-
Never
Yes,
mind.
there.
Yeah, there we
you
go.
are. All right, why don't we
All right.
carry on with you, and then we'll turn to Mr. Valderrama after that.
All right, that works for me. I'll try my best to streamline my argument where I can, just given the time and whatnot, but I do anticipate I'll be a little bit of time. I hope that's acceptable.
That's fine. That's fine.
Okay, thank you. Well, I guess just as a starting point, where this matter has come to now has become a case which is somewhat detailed and verging on theoretical. There's been reference made to the fact that Section 335 makes Section 22 of the Municipal Assessment Act somewhat of a fiction, so to speak. And essentially that Section 335 says, in my own words, to paraphrase, that one is to pretend that Section 22 does not exist. From a starting point, it's respectfully submitted that from the basics of statutory interpretation, which I will be getting into throughout the course of my submission, it's very optimistic to suggest that creating a fiction as such would have been the intention of the legislators who would be drafting these pieces of legislation, namely the Municipal Assessment Act, the Municipal Act, and so on. But where the city comes from at this point is that rather than it being convoluted and based on theoretical fictions that have arisen, this ought to be a very straightforward matter. Essentially, this can be distilled down to the fact that by definition, Red River College is statutorily exempt from municipal taxation. So that would be both school taxes and municipal taxes pursuant to Section 22 of the Municipal Assessment Act. The Municipal Act requires that institutional properties, which Red River College is expressly included as one by reference to the language of the Advanced Education Administration Act, that those types of properties pay grants in lieu of property taxes, which ought to be calculated based on taxes that would be paid if not exempt from municipal taxation. So in other words, exempt from school taxes and municipal taxes under Section 22. And it's respectfully submitted with the greatest of respect that the argument that is being advanced by Red River College in this case is essentially seeking to escape or circumvent those obligations as it relates to grant calculation. And it's respectfully submitted, as I will also get to throughout the course of my submissions, as was raised but in the questioning, express definitions in legislation do in fact take precedence. And this is something which has already been contemplated in the city's brief. And it's a long-standing recognized principle, particularly in the courts, that where something's expressly defined, that is meant to carry some weight and it's meant to have some meaning. Now, before getting into the substance of my arguments, I just want to give an overview of where I'm planning to go with my submissions. Firstly, I want to touch just very generally on the way that the legislation is drafted, and essentially that it's a reflection of policy decisions that have been made by the legislature. And that, as naturally you're aware, it's the role of the Board of Revision to interpret that legislation and to apply it. Respectfully, however, this is not the appropriate forum to effectively be changing the legislation, and that distinction is important. And it's respectfully submitted that what Red River College is seeking to do is to change the legislation as it is drafted, and in fact drafted expressly. The next point that I'll be raising is that Red River College is a creature of statute. It's subject to provincial oversight. It's subject to provincial funding. It's virtually structured by way of statute. And this is something that doing a run through of the totality of the legislation, and particularly Section 22 of the Municipal Assessment Act, this is something that is consistent with the vast majority of the other entities that are contemplated by Section 22, that they are subject to being constituted and overseen via provincial legislation. Then I would like to touch on the comment about Crown ownership and how that was altered at some point in time, and that this would implicate a change to the effect of the legislation. The city's respectful submission is that this is somewhat of a red herring. It doesn't affect the application of the legislation, as I'll elaborate upon. And then I'll be getting into my more substantial submissions. So specifically, just a general overview of taxation by municipality and where school taxes and municipal taxes come into play. I'll be brief on that because I certainly appreciate that this is something the board is very familiar with, so I don't need to go on that point. And then I'll be going through the issue of the amount payable as a grant in lieu of taxes. I would like to touch on something that becomes apparent from the legislation, and in particularly the Municipal Assessment Act, which is that if the position of Red River College were accepted in this regard, that ultimately there would be a possible duplication of the exemption in the way that the total municipal assessment and total school assessment is calculated, which is something the city respectfully submits would not have been contemplated by the legislature in drafting this legislation, effectively a double exemption being the case. And then I will go through the case law on the interpretation of the statutes, and ultimately I will conclude. So it's somewhat of a long overview, but that's the direction that I'm planning to go with this. So firstly, I wanted to touch on the concept of statutory interpretation being a prerogative and significant role of the Board of Revision versus what amounts to changing something that is expressly expressed in the legislation and codified in the legislation for that matter. Essentially, in this case, as I've indicated, it is the role of the Board of Revision to consider the legislation, interpret it, and apply it in rendering orders. And this is something that's very clear from Section 54 of the Municipal Assessment Act, as well as other pieces of the Municipal Assessment Act. Essentially, it's respectfully submitted that in this case, it would seem that Red River College is effectively seeking to change the legislation, to make it say something that isn't said, that isn't expressly contemplated, that isn't a consideration within the context of the legislation. And on this basis, the point that I wanted to make is that if there are concerns with the way in which the legislation is drafted, the proper forum to bring those issues would be through a petition to the province, perhaps. And certainly it's not my job to say how one might go about that, but that if it is effectively a concern with the way that the legislation is structured, the appropriate party to be approaching would be the legislature and seeking amendments to that legislation to reflect what is being sought, should there be merit to those particular arguments that are being advanced. So as we'll carry throughout the balance of my submissions, I wanted to raise the two issues of Red River College being a creature of statute, as well as the issue about Crown land and it no longer being owned by the Crown. I wanted to raise those at the outset as that theme runs throughout the totality of my arguments, and it provides a reasonable framework for that. So firstly, Red River College is a creature of statute. This is something that Red River College has admitted on cross-examination, and it's something that is quite clear from essentially the way the legislation is written. Essentially, it's not unlike the vast majority of the other entities that are contemplated by Section 22 of the Municipal Assessment Act. I'm looking at the Municipal Assessment Act right now, and I can see that virtually every item listed under there is one which is constituted or continued or otherwise governed by some form of legislation, with the exception of places of religious worship, for example, and places that otherwise have a significant public interest and provide a significant public service in that regard. But a common theme is that these are all creatures of statutes. Now, to be specific, the Red River College Act, I'm not going to go through all of it, but it essentially regulates how Red River College and its board operate. This is something that it was admitted on cross-examination is not the same case when it comes down to private colleges like Herzing College or Robertson College. But for example, with Red River College, the legislation, it specifies Red River College's mandate. It specifies the board's composition. It provides the lieutenant governor in council with the authority to appoint the board, in fact. It articulates terms of the board. It articulates other requirements and considerations. It dictates, so this is a statute that has come from the province. It dictates the duties and the powers of the board. It has oversight of financial matters. It provides funding to Red River College. It contains requirements for the appointment of the president of the college. It provides provisions for a student association. So essentially, there's a significant amount of power that remains and rests with the province as it relates to this type of institution. And this is also confirmed in the Advanced Education Administration Act that we've already gone over quite significantly. So therefore, in consideration of this, what the city is submitting is that not just Red River College, but also its board, which essentially owns the property, they're an extension of the province, as they are creatures of statute. They are codified and constituted through statute, which makes these entities significantly different from the types of entities that are clearly contemplated in Section 23 of the Municipal Assessment Act. As I mentioned, this is not unlike University of Manitoba, for example, which is also listed in Section 22 of the Municipal Assessment Act. So I just wanted to highlight this distinction to give some context to the totality of my arguments as I proceed throughout my submissions. Now, the other item that I wanted to touch on briefly is there was some commentary that was raised in Red River College's submissions in relation to the property previously being owned by the Crown, to summarize, and that this change in ownership has somehow altered the application of the legislation in relation to this matter. Now, firstly, do consider that, as previously indicated, Red River College is a creature of statute, so it's not as entirely divided from the province as one might suggest, or as Red River College might suggest. But to take this a step further, in reading Section 22 of the Municipal Assessment Act and Section 334 and 335 of the Municipal Act, the argument that the land used to be owned by the Crown and that it is changed, and therefore invalidating the application of the legislation, it does not squarely land on all fours. Now, the legislation is not constructed in a way that such ownership is a requirement, and this is important. Ownership by the Crown is an option. There's significant use of the word "or" throughout the Municipal Assessment Act as well as the Municipal Act. I'd like to start with Section 22 of the Municipal Assessment Act, and the piece that we're dealing with is 22B.1. Now, in determining whether or not the exemption from full municipal taxation, aside from local improvements, applies, looking at Section B.1 of the Municipal Assessment Act, it says is owned or used by. So there's reference to the word "or." ownership is one thing, use is another. Those items are mutually exclusive from each other, and you don't need both to cohesively complete the requirement for this piece of legislation. Another item that is worth mentioning is in section 22(1), the vast majority, if not all, of those entities that are listed in section 22(1), they're not on Crown land. It's not a requirement that they be on Crown land. There's a lot of use of the word or between owned and use in this case is significant. It can be divided from ownership in this regard. Essentially, ownership is not a prerequisite for a full exemption. The use of the word or is very significant. Essentially, there are some common denominators that are captured in relation to what falls under section 22 in terms of trying to understand what exactly the legislature intended in drafting this piece. It's clear that the vast majority of these items are creatures of statute. It is clear that at least in the case of Red River College, by comparison to the privately owned colleges, there's receipt of provincial funding. Essentially, those entities captured by section 22(1), they serve a greater societal purpose on a somewhat governmental level, in a widespread public scale that is funded and very much supported by the government in this regard. Such things as university education, religious worship, being funded by public funds, and so on. Now, to cross over to the Municipal Act to complete this piece on Crown ownership, I would like to start with section 334 of the Municipal Act, which deals with the definition of institutional lands, which at this point we're quite familiar with already, so I won't delve too much into it. But under 334, institutional lands definition, subsection A, there are the three items that are required for something to fall within the meaning of institutional lands. There's the land has to be exempt from municipal taxation. Number 3, it has to be used as the site of an educational institution. And then here, has to be owned or leased by the Crown, and then a bunch of other properties. And then we go to the middle of the sentence, or a college, as defined in section 1 of the Advanced Education Administration Act. Similarly, in section 335(1), there's use of that word or again. Grants must be paid in each year to each municipality with respect to Crown lands or institutional lands. So the whole point of this is just to bring it back to that distinction that Crown ownership doesn't underpin whether or not payment of grants is required by the legislation. As I indicated in a very cursory way at the outset of this, it's an option. It's ownership by the Crown or ownership by a college as defined in the Advanced Education Administration Act. Essentially, it can be a college as defined in that act that is not on Crown land. So it's respectfully submitted that what was within the contemplation of the legislature in drafting this was not that it be something that's on Crown land, but there are various options, including Crown land, including a college defined under section 1 of the Advanced Education Administration Act. Other properties, for example, the University College of the North is listed in there as well. But essentially, this is to get to the bottom of the city's submission that ownership by the Crown is not a prerequisite to a grant being payable. So essentially, just to conclude this piece of my submission before getting into the more substantive parts of my brief, the city submits that the intent and design of the legislative framework always has contemplated that Red River College was to be fully exempt from taxation and that the amounts not paid, so both school taxes and municipal taxes through the process of municipal taxation as a result of an exemption under section 22, is what was intended to form the basis for grant calculation. Essentially, what is foregone as a result of the exemption essentially becomes the basis for the calculation of the grant in question, regardless of whether it's Crown land or institutional land, or in this case, land owned by Manitoba Properties or the University College of the North. So essentially, this brings me to the balance of my submissions. So I'm just going to shift gears and I'm moving into my brief. I'll be starting at page 3, but doing my best to do an overview and summary of what's contained in there. I'll do my best to not just read it, given that you have it in front of you already. But
On that point, can you just give me a moment? And it looks like what on the front, because there are multiple briefs.
are virtually the same. There's several ones that have been filed by the city.
All right.
The one that I'm looking at is file number 20-516, 319 Elgin.
Perfect.
But if I'm not mistaken, they're all the same.
All right. Got it.
Good. All right, thank you. So I just want to go through a very general overview of municipal taxation. As I mentioned, I'm not going to get into too much depth because I understand and know the board has expertise in this field, so I'm not going to be redundant. But generally, when it comes to municipal taxation, that is an overarching term or an act that is performed by the city. And it is comprised of the imposition of 2 different kinds of taxes. So that would be school tax as well as municipal tax. Now, the provincial government's Public School Act, it essentially directs municipalities to bill for and collect and remit to the province school taxes. And these essentially come in 2 different forms. There's the education support levy, which is remitted by the city to the province. And then the province adds a grant, and these are essentially used to pay operating costs of school divisions. Then there's the school division levy, where the city remits the amounts that are collected to each school division to assist with payment of operating costs. So that's one chunk of taxes that is captured by the overarching act of municipal taxation. The second chunk is what's known as municipal taxes. Essentially, it's street renewal levies that are used for maintenance and repair of existing infrastructure, as well as local improvement levies. And these go towards such things as sidewalks and boulevards and installing ornamental streetlights and that type of thing. So the reason I raise those items is just to make clear that there is a distinction between municipal taxation and municipal taxes. Municipal taxation, as it's respectfully submitted, is referred to in the Municipal Act, is the physical act of taxing. And the taxing that is contemplated would be school taxes and municipal taxes. And then on page 4 of my brief, I've set out how an example calculation would work. I'm not going to go through that in detail now, but I just wanted to make that distinction clear that when I'm referring to municipal taxation, I'm not referring to municipal taxes. I'm referring to a combination of school taxes and municipal taxes and the act of collecting those. Now, I'd like to get a little bit more into the distinction between Section 22(1) of the Municipal Assessment Act and Section 23(1) of the Municipal Assessment Act, and particularly the reference to the 2 different types of colleges contained therein. And I've already given the context for how it's quite clear that Section 22(1) contemplates creatures of statute that have provincial oversight and funding. Now, essentially, Section 22(1) of the Municipal Assessment Act provides full exemptions from municipal taxation aside from local improvement levies. So that's both school taxes and municipal taxes. The properties are exempt from that. So these are essentially institutions or facilities that derive their constitution and or mandate from statute and that sort of thing. And it's respectfully submitted that this is where Red River College falls in the first instance. I don't think that's disputed, but it's respectfully submitted that this is where it falls again when we get down to grant calculation, as I'll elaborate upon shortly. Now, Section 23(1) of the Municipal Assessment Act, which has also been discussed at length, provides exemptions to what's respectfully submitted is a separate conglomerate of facilities or institutions, which by way of generalization can be described as being privately owned. As was previously raised, and as I'll be elaborating upon further, it's respectfully submitted that this section isn't considered to be a broader scope section, that essentially if section 22, for lack of better words, disappears, everything suddenly falls under 23. No, it's respectfully submitted that the distinction that's important is in section 22, you have the colleges that are defined and constituted and governed by legislation. Section 23, you have the privately owned colleges, which has, as indicated through the cross-examination that was performed in respect of Herzing and Robertson College, as well as throughout my submissions to date, is a significant distinction. And as was also raised in questioning, not by myself, I forget which member of the panel it was who raised this, it is important to note the distinction that the legislative drafters did clearly exclude reference to the Advanced Education Administration Act in Section 23 of the Municipal Assessment Act. And it's respectfully submitted that this is for a reason. It is not an omission. It's not something that was simply it's not something that was simply forgotten, but rather it was intended. It was intended that those colleges captured by the Advanced Education Administration Act fall under Section 22 for all intents and purposes, and that other legislation ought not to be construed to essentially invalidate that very calculated and pointed policy decision made by the legislature. Essentially, it's significant that in Section 22, which immediately precedes Section 23, reference to that legislation was included. And then you get to the next section, which literally follows it, and it's excluded. It's respectfully submitted that that is significant in this regard. So to generalize, I'll be shifting gears now into the grants in lieu of taxes piece of my argument. Red River College is now arguing that the grant in lieu of taxes, which it's required to pay, somehow ought to be interpreted in a manner that only municipal taxes ought to underpin the calculation of grants payable in lieu of taxes. So essentially, and I'm paraphrasing here, I'm not trying to misstate, I'm paraphrasing. Essentially, it sounds as though Red River College is taking the position that even though it qualifies for a full tax exemption under Section 22, Section 335 of the Municipal Act has been drafted in a manner that suggests Section 22 doesn't matter, it doesn't exist. Now everything falls under Section 23. And it's respectfully submitted that this approach would lead to an absurd result, as I've particularized in the balance of my brief and as I'll elaborate upon now. Now, I'd like to begin with an overview of Section 334 and 335 of the Municipal Assessment Act. Now, it's important to note that, as I've already gone through, the institutional lands section of Section 334 defines an important term that arises throughout Section 335. And essentially, that's the concept of institutional lands. And what's important to note here is that in Section A and then little bracket sub 2, that piece talking about owned or leased by the Crown or a college is defined in Section 1 of the Advanced Education Administration Act, is the parallel between the two pieces of legislation. This language is virtually identical, that being the reference to a college as defined in Section 1 of the Advanced Education Administration Act. It's almost parallel or identical to the language that is used in Section 22B.1 of the Municipal Assessment Act. It's respectfully submitted that this was not inadvertent. This was not by accident, that this was clearly contemplated, and that it was the intention of the legislature to make sure that these pieces of the Municipal Assessment Act tie directly back to Section 22, of the Municipal Act, tie directly back to Section 22 of the Municipal Assessment Act. There is nothing in this part of the legislation that says, well, if you're calculating grants, we're going to direct you to Section 23 of the Municipal Assessment Act. There's no reference to that at all. If anything, this is the argument being advanced by Red River College is somewhat speculative, it's somewhat presumptive, and it's not based in the fact of the language of the legislation that is clearly contained within these pages. Now, Red River College has advanced a 3-step analysis that I would like to address in the course of my submissions. Essentially, it's a 3-step analysis that tries to explain how Red River College has arrived at the conclusion that it has. Firstly, it is stated that you need to consider Section 21B.1 of the Municipal Assessment Act. And this is the part which clearly and expressly exempts Red River College from municipal taxation. The city concurs with this. This is a very logical starting point because that's where Red River College falls within the legislative scheme under Section 22(1)(b)(1). Then the next step, which is proposed by Red River College, is you need to consider Section 335 of the Municipal Act. Absolutely. Absolutely, that needs to be considered. However, Red River College then goes on to suggest that the language, the amount that would be payable as taxes under this part in respect of the property, if it were not exempt from municipal taxation, ought to be construed as something on the lines of, as though the exemption under Section 22 just wasn't there. And the city does not agree that this would have been the intent of the legislature. The city's respectful submission is that the legislature would not intentionally create a fiction, would not intentionally create legislation or provisions that effectively invalidate another section and complicate matters without expressly saying so. And then the next step that Red River College has touched on is that one ought to examine the balance of the Municipal Assessment Act as though no consideration or deference is owed to the explicit language of Section 22 at this step in the analysis of calculating a grant. In the city's respectful view, this position is somewhat illogical, for lack of better words, respectfully. It does not seem consistent with what the legislature would have intended. And to take this a step further, Red River College suggests that if the provisions of Section 22(1)(b)(1) are virtually disregarded, then Red River College must automatically fall under Section 23. And particularly, that part which provides a school tax exemption only to properties held in trust for colleges or seminaries of learning. Now, as a starting point, as I highlighted at the outset of my submissions, it's respectfully submitted that Section 23(1)(d) is intended to capture privately held colleges. So already from the overarching legislative scheme, it does not seem consistent with the legislative intent that now Red River College would suddenly fall under this section that it was expressly hived out of in being put into Section 22. It seems inconsistent that the legislature would use the Municipal Act to somehow alter what the Municipal Assessment Act already says. Essentially, it is respectfully submitted that Red River College is somewhat attempting to manipulate the legislation, where it's perfectly okay being fully exempt from municipal taxation other than local improvement levies. But then when it comes back to actually paying a grant, it is trying to manipulate the legislation so that it has to pay a smaller grant than would otherwise be expressly stated and contemplated within the confines of the Municipal Act. Given the reference and the express language which mirrors that of Section 22 of the Municipal Assessment Act, it's respectfully submitted that this interpretation of the legislation put forward by Red River College is improper and respectfully is simply wrong. So that's where the city's position is in relation to the amount of the grant that is payable. As I said from the outset, this ought to be a very simple and straightforward matter. Red River College falls under Section 22. The Municipal Act says if Section 22 did not give rise to an exemption, or essentially if the city was not exempt from municipal taxation, so if it wasn't exempt from municipal taxes, from school taxes, what would that amount be that it would otherwise pay in taxes? It's respectfully submitted that Red River College would not automatically default to a section it wasn't intended to fall within, but rather you take municipal taxes, you take school taxes, and use that as a basis for the grant calculation. And on a balance of probabilities, it's respectfully submitted that this is the most reasonable interpretation because that is actually what's clear on the surface of the legislation, rather than the suggestion that the legislation is attempting to create a fiction of sorts. That seems less clear from the legislation, so to speak. Another concern that goes to the concept of legislative intention is in reviewing the Municipal Assessment Act, and I emphasize and highlight that it's important to consider the totality of the legislative scheme. In looking at the Municipal Assessment Act, it would seem that there is a potential for the exemption to be counted twice if Red River College were in fact correct in its submission. I have outlined this at page 9 of my brief, but I'll try to go through it carefully at the same time. So starting at page 9 of my brief, that being paragraph 29, we're dealing with the definitions in Section 1 of the Municipal Assessment Act. So specifically the definitions of total school assessment, which I'm starting with first, as well as that of total municipal assessment. Now, as it relates to the total school assessment, this is used, for example, by the province or the school divisions for calculating their mill rates and levies, the ones that I highlighted at the beginning of my submissions. And what is considered by the assessor is the aggregate of, and this is the most important piece, the total municipal assessment. So it would be the aggregate of the portioned values for the total municipal assessment, as well as personal property, which doesn't factor in here. And then you subtract the aggregate of the portioned values of real property in the city that are exempt from liability for school taxes. So essentially, you start with the total municipal assessment, you take out the school taxes in very simple, basic terms, and that's how you arrive at the total school assessment. Now, we take it a step further. That section also defines the meaning of the total municipal assessment, which I've already highlighted is factored into the calculation of the total school assessment. Now, the total municipal assessment, it considers the aggregate of portioned values that are applicable to a number of things, but the most important being to institutional lands as defined in the Municipal Act, as if amounts paid as grants in respect of such properties in the place of taxes were payable as taxes. Again, this language is starting to surface again. And it's respectfully submitted that if Red River College were in fact correct that the calculation of the grant should exclude amounts associated with school taxes, then that value would go into the calculation of the total municipal assessment, with school taxes being eliminated at that stage, And then you'd take the total municipal assessment, move it into the total school assessment, and again, take out the portion values associated with an exemption from school taxes. School taxes in this case would be deducted twice. Essentially, the exemption has the potential to open a can of worms wherein there would be double counting of this particular exemption in the city's respectful submission if the position advanced by Red River College were in fact correct. Now, I'd like to briefly highlight some of the legislation, not the legislation, my apologies, the case law relating to interpretation of statutes. The city is largely in agreement with the authorities on this point that have been put forward by Red River College. Those do seem to be the standard and consistent pieces of legislation in both Manitoba as well as in the country as it would relate to statutory interpretation. So I'm not going to take time disputing those pieces of case law, but I would highlight a couple items that go to statutory interpretation. For example, and now these are in the city's materials, the city's included a 2004 decision of Justice Beard, the Assessor v. Loveday Mushroom Farms Limited. And this is one of the prevailing cases in the province as it relates to what principles have been adopted in terms of statutory interpretation. So essentially, again, as was indicated by my learned friend, interpretation of taxing legislation should follow the ordinary rules of taxation. Legislative provision should be given a strict or liberal interpretation depending on the purpose underlying it, which I've been canvassing throughout the course of my submissions. What exactly was intended? What exactly is the purpose of these pieces of legislation? The teleological approach, it says it will favor the taxpayer or the tax department depending solely on the legislative provision in question and not on the existence of predetermined presumptions. Now, this is important, and it's respectfully submitted that assuming that the legislature intended to create a fiction, respectfully, is one of those predetermined presumptions which ought not to factor into matters which are being analyzed using the teleological approach of statutory interpretation. Essentially, substance should be given precedence over the form to the extent that this is consistent with the wording and the objective of the statute. So essentially, looking to the substance of the overarching pieces of legislation is important. And only a reasonable doubt, not resolved by the ordinary rules of interpretation, will be settled by recourse to the residual presumption in favor of the taxpayer. Now, I note this because it needs to be a reasonable doubt, not resolved by the ordinary rules of interpretation. And it's respectfully submitted that there is no doubt, based on the way that the legislation is constructed, that it is the taxes which Red River College are exempted from paying under Section 22.1, which form the basis for grant calculation under Section 335. It's respectfully submitted that the arguments raised by Red River College do not give rise to a doubt that can be defined as reasonable in the circumstances. The majority of the other cases that I have included at pages 10 and 11, as well as attached to the brief, or I guess they're not attached, but that I've cited within the context of this brief, they basically say the same thing, talking about the teleological approach in the entire context of the legislation. But one that I did want to draw attention to is the reference to Winnipeg Assessor versus Concordia Hospital. This is a decision from 2002 of the Manitoba Court of Appeal. And in that case, there is comment upon the influence of express definitions when contained in one of those sections, Section 22 or Section 23. Now, to be fair, the Concordia Hospital decision, it didn't involve these particular properties. It didn't involve a college. In fact, it involved the Concordia Hospital, but it engaged the same issues involving statutory definitions. And so what I have done is I've taken that decision, I've lifted the language, and using the exact same format and analysis involving the use of definitions in legislation, I've drafted the identical analysis using our facts and using our pieces of the legislation. And I would like to draw your attention to the last 2 bullet points at the, it's about halfway down page 12 of the city's brief. And again, this is using language that's been lifted directly from the case law and inserting the names of our entities. Red River College is by definition a college, as contemplated specifically by section 22(1)(b)(1) of the Municipal Assessment Act, and because of that, cannot avail itself of the taxation provisions and benefits flowing therefrom, and in this case, as would apply to private colleges under section 23 of the Municipal Assessment Act. And it's respectfully submitted that for municipal taxation purposes, Red River College has to be treated as it is presently defined. And that is, as a college, as defined in Section 1 of the Advanced Education Administration Act, and as expressly contemplated by Section 22(1)(b)(1), to the exclusion of any additional or inconsistent treatment under Section 23. So essentially, a thorough review of the principles that are given rise to in the Concordia Hospital decision makes it clear that where there is something that's defined, that definition takes precedence. It is a clear indicator of the intention of the legislature, and it ought not to be taken lightly. It ought to be considered seriously. I won't get too much into other arguments on this own point, or on this same point, but this principle of legislative definitions taking precedence over and above more general concepts. It's something that has been explored at the Supreme Court of Canada level, Manitoba Court of Appeal, Court of Queen's Bench. It's not a novelty. It's a very well-established principle that has been used, at least as far as I know, and certainly far longer than that, in interpreting statutes. Now, just to summarize and conclude, it's respectfully submitted that it would be improper and lead to an absurdity in the circumstances to suggest that the legislature intended for both sections to apply to Red River College. Indeed, Red River College was expressly placed within Section 22 of the Municipal Assessment Act for a reason. And it's respectfully submitted that this exemption decision was based on policy considerations that are within the sole discretion of the legislature. In applying the teleological approach, it's respectfully submitted that it's improper to make predetermined presumptions, such as, well, if this piece of legislation potentially says that Section 22 doesn't exist and Section 23 must apply. It's respectfully submitted that that's the type of predetermined presumption that would be captured by what would be improper within the scope of the teleological approach. And it is the existing legislative provisions in question, the present construction thereof, the express language used therein that should take precedence in this regard. So in conclusion, the city's interpretation of the legislation, it's not only based on the clear language in question and the context in which it is used, but indeed, it's respectfully submitted that if one reads it harmoniously with the overarching intent and scheme of the acts that are engaged in this particular dispute, the object of those acts, what would clearly seem to be the intention of the legislature, a balance that is fair is achieved. And this does not permit improper duplication of an exemption or a risk thereof. So it's respectfully submitted that it is this interpretation that ought to govern essentially what is clear from the legislation and not some alternate interpretation that isn't expressly contemplated anywhere for that matter. So in conclusion, the city's position is that the amount of the grant payable by Red River College in lieu of taxes pursuant to the Municipal Act ought to be calculated based on the amount of school taxes and municipal taxes that Red River College would otherwise be exempt under Section 22, exempt from paying. So subject to any questions that there may be, that would be the totality of my submissions. I'm certainly open to questions. I'm not sure if Mr. Chair would like Mr. Valderrama to speak before questions or what's preferable procedurally.
I think it would be preferable to ask you questions first, and then we'll move on to the
Sure.
value issues.
Absolutely.
So, Mr. Reimer? Mr. Reimer, do you have questions?
Indeed, I was speaking without my microphone on. Thank you very much for reminding me of that. Thank you, Ms. Baumbach, for your presentation. I've got a couple of questions and a couple of observations with respect to the decision that you cited in your materials. Now, and this is in reference on your page 4, it's paragraph 11. And you brought this up as well, Ms. Baumbach. Section 23 provides exemptions to a separate conglomerate of facilities, which by way of generalization may just be described as privately owned. But certainly we'd agree that when you look at Section 23, and you haven't referenced it in your materials, but I'm now at our page 55 of our main brief, so you're welcome to turn there if you would like to. But we've got Section 23(1)(b) where the exemption relates to a nonprofit organization, charitable organization, or municipality as an elderly person's housing unit. So certainly a municipality is not a privately owned institution, right? Facility. We could agree on that, correct?
Absolutely, yes.
Okay. And similarly, when one goes towards the bottom at subsection I, a further exemption under 23, it says if it's owned by or held under leasehold title by a municipality, community association, service group, public recreation commission, or other public body. So again, that's a public policy decision, but it's separate and apart completely from a private organization, correct?
A municipality, yes, that's fair.
Or other public body.
Yes.
Okay. So when we move to page, sorry, and I'm going to take a quick, on page 3 then, and there's no disputing what you've presented, that there's the education support levy, the school division levy, the municipal levy, and frontage levies. So all of that together at the bottom of page 3, you said that school taxes and municipal taxes are billed to property owners through the process of municipal taxation.
Correct.
Okay. Okay. So now, very briefly, if we go to page 10, and I'm trying to understand this because I think I still don't quite understand the thrust of the argument. So this is referring to paragraphs 30 and 29, and you've suggested that the position taken by Red River is going to result in sort of an exemption counted twice. But in reading these through, and I took, of course, a careful look at the Municipal Assessment Act. So in defining or in calculating the municipal assessment, the total municipal assessment, that is taxable real property, mobile homes in some circumstances that we're not concerned with here, and institutional lands. And we can agree, and for clarity, if I haven't made this clear, like we're not in any way suggesting that the grants wouldn't include the municipal grants under the Municipal Assessment Act. So the portion value of the subject properties being part of the total municipal assessment. That would be step one. But then as you've identified, the total school assessment, by definition, this would be, I'm suggesting to you, and if you disagree, then let's discuss it now, because I believe the total school assessment in reading this is, first of all, the aggregate of the total municipal assessment, which was calculated earlier, including the various properties that are otherwise school tax exempt, and the portion values of personal property, that being whatever it is, but then less the aggregate of the portion values of real property in the city that are exempt from liability for school taxes. And I guess I'm suggesting, Ms. Bombach, it's as simple as you would with any other property where there's a school tax exemption. You take that portion value out, as the city already does, and you would do the same thing here should the board decide to exempt the subject properties from school tax exemption. So did I miss something there? Because the process is the very same as would be done with school tax exempt properties now, and I guess I'm suggesting any fault or any difficulty in calculating would arise now with other school tax exempt properties.
Okay, I do see what you're saying, and thank you for that question, Mr. Reimer. Essentially, the position that the city is taking in regard to this piece is it's a question of inconsistencies within the legislation. I'm not speaking about in practice, I'm speaking about statutory interpretation and how it seems inconsistent with the intent of the legislation. That in one place, so for example, in calculating the total municipal assessment, I'm just trying to make this as simple as possible so I don't reiterate my whole argument, but essentially saying that you have the school, if Red River College's position is correct, you would be removing the school amount in the calculation of that piece relating to institutional lands. So you take it out the one time in doing the total municipal assessment. And then in calculating the total school assessment, you take that total municipal assessment, which has already had the school amounts removed, and then remove the school amounts again. So it was just a commentary in relation to statutory interpretation. It's outside the scope of what would be done in practice and that sort of thing, but going to the core of what the legislative intent would have been is that it would seem as though it would give rise to the potential for a double exemption, for lack of better words.
Okay, I'll work with that on summation. I suggest, Ms. Bombach, in fairness, I don't think that's the case. I think that's resulted in a formula that it's not nearly as complex as it actually is. And to be clear, we're not suggesting that the properties here should be removed from the total municipal assessment. We very much are suggesting they should be removed in the calculation from the total school assessment. But in any event, you've gone through that twice now. I'll leave that for summation.
All right.
Now, in the case of, now I'm on your page 13.
All right.
And your reference to the case of Winnipeg City Assessor versus and Concordia Hospital, which is the Court of Appeal decision.
That's correct.
So we can agree there, though, and I've got the case in a separate submission to the board, just that case itself as you've raised it.
Thank you.
The issue, and I'm reading from paragraph 3 of that case. The issue in this case is whether the personal care home, Concordia Place, is to be treated as a personal care home or as a hospital for purposes of taxation. So, and you alluded to this. In this case, there was a question of the definition of hospital versus a very separate definition of personal care home. We can agree to that extent on this case, correct?
Yes.
Okay. I will refer to that briefly in my reply. And I think the rest of it I will work with in reply.
Okay, and just to add one piece to that comment, it's the principles relating to the significance of definitions used in statutes that are being drawn upon. It's not something that would be fact specific, but it goes to the issue of where something is expressly defined. That definition ought to be heeded and respect ought to be afforded to it.
Understood. again, the context being an express definition that wasn't hospital. It was the express definition you're referring to in that case was the definition of personal care home, correct?
Yes,
Okay, as opposed to the definition of hospital.
yes.
Okay, thanks. Mr. Chairman, those are my questions. Thank you.
Mr. McIntyre,
I have no questions. Thank you.
Ms. Nesbitt.
No, I have no questions.
I have a question just on that last point about the Concordia
Yes.
court case. Did that case elaborate on the principle of express definitions versus general, or is this something that you're reading into the fact that they defined personal care home as being something that is not a hospital?
If I may, I'm just going to pull up the case so that I can expressly refer to it while I respond to you. If I might just have a moment to do
And
that.
certainly,
And
I
Mr. Chair,
vote well.
Mr. Chairman, I have submitted that case as well. So if the board members and Ms. Bombach want to refer to that,
And where's that in your document?
that is actually just the one court case. It's 2 pages long. It's a separate submission from the main brief.
And it is 2 pages. Well, you know what? It's easier for me to look it up.
Second one down.
Okay, so the case itself, I'm primarily relying upon paragraphs 6 and 7 thereof. It's thankfully quite a brief case. It's only 8 paragraphs long. But in those particular paragraphs, indeed, it is referring to a personal care home as opposed to a hospital, but it does tie in with the significance of definitions and how deference ought to be afforded to definitions within the context of Section 22 and Section 23 of the Municipal Assessment Act. So the reason this case law is being relied upon is by way of analogy, if that provides any assistance.
Okay, so it's an analogy.
Yes.
The personal care home being separate from being a hospital, which is what the court found, rather than this is not an explanation of the general interpretation principles of express versus general and that sort of thing.
No, that's correct. It's by way of analogy how a court has considered a similar situation and how they applied the definitions within the context of these 2 provisions of the Municipal Assessment Act.
Okay. Right, those are my only questions. So then we have the issue of what is the impact on the value, which I assume Mr. Valderrama will address. Is that correct?
I'll be doing the quantum, yes.
Okay, so I guess my first thing that I would want to clarify is the agent has provided information with respect to all of these properties, and is the city disputing the agent's determination of the application of value to the various classes, or in agreement with any of them?
I think with regard to the facts and the property or physical property attributes, I think there's no dispute on that. It's just when classification and liability becomes in their favor, then I mean the calculation would be different, right? Or the distribution of
right.
the liability will be different.
So in other words, we need to go through each one of these.
Yeah, just to give the facts and how the classification and liability are determined from our perspective.
All right. If you could do that, then beginning with 319 Elgin and do it as expeditiously as possible.
I can do that, Mr. Chair. So the first one has a file number. If I can just pull it up. Here we go. File number is 20-626. Has a roll number of 130-990-71910. It is located at 319 Elgin Avenue.
Could you hang on just a second, please?
Okay.
The file number was 626, is that correct?
Yes, I think that's the first one in the docket.
Yeah, we don't have that.
Oh, yeah, we don't have that.
It's on there at the top.
Brent, are you saying that you have this?
Yes, we do.
Electronic.
Electronically. All right. Just give me a moment to get there.
Yep.
All right, carry on.
Yeah, and to clarify also, this specific roll number amalgamates 4 other roll numbers with 4 other file numbers.
Okay.
And this is a supplemental assessment. It has a roll year of 2020. Given a reference date of April 1st, 2018, the assessed value is $1,550,000. It has a classification of an institutional property and a liability of grantable. So there are 3 stories, and the property type, by the way, is a PIIUC, or university/college. It has 3 stories, 1 section, and effective years built of 1958 to 1975. Its construction class is masonry bearing walls, an average wall height of 13 feet. The property is zoned as C or character. It has a land area of 28,138 square feet, a planned area of 6,326 square feet, a basement area of 6,326 square feet, with a gross floor area of 25,304 square feet. And I'm just gonna go on page 15 of the brief. It has the photos of the subject property, has the aerials of it. And on the next page, page 16, I believe, it has the zoning.
If you don't mind, just a brief interruption here. Please, panel members, let me know, and same with Mr. Reimer. Since value has not been appealed here, and we've been talking about these properties quite a bit, I'm suggesting that perhaps we don't need a lot of description of the property, but rather a zeroing in on the separation of value by class in accordance with what the city sees as the liability and the reasoning for it. Does anybody mind doing that, or would you prefer that we go through much more detail?
I don't mind doing it.
I have no objection to limiting the discussion, Mr. Chairman, to the way you framed it.
Okay. Panel members?
Yeah, I think that's a good approach.
I agree.
All right. In that case, Mr. Valderrama, could you please just confine your remarks to how the value has been separated between the classes and the justification for it?
I can do that, Mr. Chair. Okay, so so for that, just a clarification, Mr. Chair.
Mm-hmm.
So you want me to go over it's basically on my first page of all of the briefs. Would you just want me to go over on the first page, or?
I would suggest that in
Yeah.
case, or unless somebody has any objection. I don't think we need to spend time on what the physical characteristics are or photos and that sort of thing. Really, what is germane here is, given the legal arguments, in your case, how does that shake out as a separation of the value between the classes?
Okay, that sounds good. All right, I can do that. And if you want me to go more in details, then you can just ask questions or anything. That. Okay, so I'm gonna proceed with the next property then, Mr. Chair.
All right.
The file number is 20-520, and its roll number is 13096193600, and it is located at 504 or 504 Main Street.
If you'll just give me a second to find that in the electronic
Okay.
submissions here. You said 520, is that correct?
For the file number, it is 520, yes.
All right, I'm there. Is everybody else there?
Yes,
Panel members?
yes.
All right, thank you. Go ahead.
Okay, so the roll number is 13096193600 and located at 504 Main Street. So there are two classes and liabilities on this one. The first one is an institutional property grantable and assessed at $9,479,000, given a reference date of April 1st, 2018, and the roll year of 2021. The second assessment on this one has a classification of residential 2 with the liability of grantable. It is assessed at $7,900,000. Again, same reference date and roll year at 2021.
Could you just give us a brief explanation of how that separation was made? What is the math that was followed to make this separation?
Okay, I'll just gonna go to, hang on 1 second. Just looking at that. Okay, on page 21 of my brief is the summary. So the first section you'll find on the land valuation section, I should say, there were two class and liability splits. The first one has the 40G or the institutional grantable for land valuation. It has a net area of 12,187 square feet, given a net rate of $106.10, giving it a land valuation of $1,293,000. And then the second one in land valuation 2 has the 20G class and liability, has a net area of 7,312 square feet, same net rate or land rate of $106.13, giving it a land valuation of $776,000. And then if we proceed to the building section, the first site or the first building portion is determined at $8,186,000, has a total or a class code of 40 and a grant liability of grantable. And the second one is $7,124,000, which is the 20 residential grantable.
Okay.
And yeah, I think that's it.
Okay.
Those are the separation or the and do we have any clarifications or any?
Is there any questions about those?
Yeah, I just want to clarify, I'm actually cross-referencing to Mr. Reimer's presentation. So on page 4, that's the Patterson Global Foods Institute, right? And the first through third floors are the hospitality and culinary arts programs. That's the 40G component. And the rest are the dormitories in the 4th through 10th floor. That's correct?
Yes, and they're based on areas. Yes,
Yeah.
that's correct.
So I'm just cross-referencing there so I know what the use is.
Okay. Perhaps it would work a little better. I was going to have Mr. Valderrama go through these and then we'd ask questions of the whole lot, but perhaps we could do this one at a time. Mr. Reimer, do you have questions about the information that has just been provided to us?
No, Mr. Chairman, thank you.
All right.
Thank you.
Then shall we move on to 2522?
Okay, Mr. Chair, I'm on it.
Let me find it. I have it. Other panel members, do you have it?
Yes.
All right. Carry on.
Okay, the next one has a file number of 20-522. It has a roll number of 13096031000 and located at 160 Princess Street. We're dealing with the roll year of 2021. Given a reference date of April 1st, 2018, the assessed value is $32,961,000. It is classified as an institutional property with a liability of grantable. So if there's any questions, or any more information that you need, Mr. Chair.
Okay. Do you have a similar page? Going to your page 21 again. Is there anything else there that needs to be elaborated upon?
Page 21. Yeah, these are the cost or the more details of the property. Again, the land valuation, it has a net area of 61,886 square feet using the net land rate of $22.80, giving it a land valuation of $1,411,000.
Okay.
And then
We don't, it's not so much, I guess it's really the separation between the classes
that's
in here.
Mr. Chair.
That's good. Mr. Reimer, any questions there?
No questions. Thank you, Mr. Chairman.
Panel members?
I have no questions. Thank you.
Okay, carry on.
Thank you.
We'll go to 515.
Okay, I'm on it.
Go ahead.
Okay, the next one has a file number of 20-515. It has a roll number of 13096159200. It is located at 275 Bannatyne Avenue. We're dealing with the roll year of 2021. Using the reference date of April 1st, 2018, the assessed value is $300,000. It is classified as an institutional property with the liability of grantable. And any more information that's required, Mr. Chair?
Okay, Mr. Reimer,
No questions.
No questions.
panel members?
I have no questions.
No questions.
All right. And then the next one.
Okay, the next one has a file number of 20-521. It has a roll number of 07569136560. It is located at 2055 Notre Dame Avenue. There are two split classifications on this one. The first one, as mentioned earlier, presented by Mr. Reimer, it is the daycare. With the roll year of 2021, using reference date of April 1st, 2018, the assessed value is $67,000. It is classified as an institutional property with the liability of exempt. The next split classification or split assessment is given a roll year of 2021 using reference date of April 1st, 2018, the assessed value is $64,542,000 and classified as an institutional property with a liability of grantable. And any more, or you want me to go further, Mr. Chair, or?
Just the exempt portion of that, if we go to, what is it, your page 21 again?
Yes, I think so. I'll double check on that one.
I believe it might be, Mr. Chairman, I believe it might be page 25.
25.
Oh, it's farther down. Yes, it's 25.
Okay, got it. All right.
Just, do I need to go over it, Mr. Chair, or?
No, I think that just looking at it
Okay.
is
I
fine.
do have a couple of questions on this particular one, Mr. Chairman.
Certainly, go ahead.
So on page 25, if Mr. Valderrama, if board members are on that page, so as I understand it here, this is the, and we've both alluded to it, this is the exempt, the daycare is exempt in the amount of $64,000 under section 22(1)K of the act, correct?
Yes, that's correct.
And the remainder is considered by the department to be grantable under 22(1)B1 then, correct?
Yes, that's correct.
Thanks, Mr. Chairman. Those are my questions.
Fine.
I have a
Okay,
question.
then lastly,
I have a question.
5. Oh, I'm sorry.
I have a
Sorry,
question.
Ms. Nesbitt?
Yeah, I'm just looking at that table on page 25. It does refer to the daycare portion as 64,000, but the front page refers to 67,000. So I just want to make sure that we're using the right number.
Good catch.
Yes. Just looking at the summary here.
Then I think I'd want to add up the 40G portion as well to make sure those numbers are consistent.
I'm just gonna double check on that one. I'm looking at the attachment or brief. Nope, it's not here. Must be the rounding error, but I'm trying to. It's giving me a different one. It should have been 67,000, but should be a total of 67,000, Mr. Chair. I'm not, don't have the cost report here, but
67,000 is the figure that should be used.
it should be 67,000, Mr. Chair.
All right.
And then just on the 40G portion, there is the $3,000 or 3,000 discrepancy
Mhm.
comes into play there too. So I just want to
Was the-
confirm it's 64,542, not
Yes, that's
64,545.
that's correct.
Okay. So what the correct number is actually on the front of the brief.
Yes, that's right. Could have
Okay.
been some error.
All right, that's fine then. So let's move on to 2523.
Okay, 2523. Okay,
Yes.
I'm on it.
Okay, go ahead.
Okay, the next property has a file number of 20523. It has a roll number of 07042197400. It is located at 2280 Saskatchewan Avenue. Given the roll year of 2020 and using reference date of April 1st, 2018, the assessed value is $6,215,000. It is classified as an institutional property with the liability of grantable. And any other information that's needed, Mr. Chair, or any questions?
Panel members, do you have any questions?
No.
I have no questions, thank you.
Mr. Reimer?
I have no questions. Thank you.
All right, that completes that. Now, Mr. Reimer, do we need to go over valuation separations as you have made them in your briefs, or would you like us to rely on the written copy?
I haven't gone through it. I'm happy to go through it again, but I would ask that the board, if the board chooses to grant the request, to use the allocations as I've suggested in our materials. It
All
will
right.
apply to 2055 Notre Dame and to 2280 Saskatchewan, and also recalling that in the case of Elgin Avenue, it's a construction site right now for the most part.
Correct. All right, thank you. Well, in that case, I think we're down to summations. Mr. Reimer, would you like to go first?
Thanks, Mr. Chairman. I want to briefly allude to the court decision that Ms. Bombach had presented, and my suggestion is very much that case can be distinguished. In paragraph 7, that case related to, as Ms. Bombach correctly identified, it was the Concordia Hospital, and then there was the personal care home that was actually attached by a hallway, and all part of that same site. But in that case, the definition, or the case revolved around two entirely separate definitions. One was of a hospital, and what the applicants in that case were asking was that the personal care home be fully exempt as a hospital, as defined. And what the department was suggesting was that, no, this is a personal care home, which is an entirely separate exemption for school taxes only under section 23. And in paragraph 7, the court did make the finding, of course, that the personal care home is properly defined. Says the Health Services Insurance Act defines a personal care home as being a personal care home as designated in the regulations. This resolves the issue of this appeal against the hospital. Concordia Place is, by definition and regulation, a personal care home, and because of that, cannot avail itself of the taxation provisions that apply to hospitals. So it was two entirely separate entities that were under discussion. Under Section 22, hospitals, of course, are fully exempt, and then personal care homes are separately listed under Section 23. But that's not what we have here. What we have here fundamentally is college and college. The college in Section 22 being the more specifically narrowly defined college under Section 22, but Section 23 has the broader word college which I'm suggesting would, in any reasonable interpretation, include Red River. We can actually agree upon more than we disagree upon, and Ms. Baumbach was forthright in her comments, and we're agreeing in many respects. At the heart of this issue, Mr. Chairman, are a couple of things: the principles of the grant system and grants in lieu, and what that system is intended to, how it's intended to operate, what the term college means in the Act, and how to give effect to Section 335 of the Municipal Act. Now, Ms. Baumbach, and I fear that I've not presented this well based on Ms. Baumbach's statements. Ms. Baumbach had suggested that somehow Red River's position was because the property transferred to from HMQ to the Board of Directors of the college, that somehow the application of the legislation changed. Not at all. Not at all. And I want to be very clear on this. The reason for talking about HMQ as the owner and then the shift to Red River College is it sets the context for the legislative scheme. Recall that I was saying that in the legislative scheme, you're starting with 22 and then moving to 335, but Section 22 is there because Crown properties and institutional properties, no debate on that, Crown properties and institutional properties are captured within Section 22, and institutional properties are defined under the Municipal Assessment Act. But that sets the stage for, by virtue of 335, how to give effect to the wording of the section and to the entire intent of the grant system as to what a fair amount is. And this is, again, where we diverge. That's the third step. We're agreeing that Red River College, as a college under the Advanced Education Administration Act, as the more narrow definition is in 22, we're agreeing they're fully exempt, other than local improvements. We're then agreeing you have to go to 335 because of the Municipal Act, but for that, the college wouldn't be paying any taxes whatsoever. But this is where the divergence starts. And it's the wording in 335 that says the taxes that would be paid in respect to the property if it were not exempt from municipal taxation. We're suggesting that, and you know, a lot was made of the word fiction. That was perhaps not a judicious use of the term. But in order to give effect to that wording and the intent of the grants program, you have to look at what the nature of this, what you're left with when you've gone to Section 22 and you've gone to 335 and you say, okay, what would this property be paying if it were not exempt from municipal taxation, which I'm suggesting it relates to Section 22. Okay, you've still got a college. Under any reasonable interpretation, you've got Red River College, the oldest institution, the second largest institution in the province. It's a college. And to suggest that somehow, for the purposes of Section 23, the word college should exclude them, that, in my respectful submission, should have been made very, very clear, and there's a reason it wasn't. There's all of these exemptions in both 22 and Section 23 are based upon various public policy considerations. Ms. Baumbach had made reference to the fact that generally Section 22 is the public bodies and Section 23 relates to, in general terms, privately held bodies. That's not the case. I had alluded to it, and I would refer the board to my pages 55 and 56. You don't need to turn there now, but it gets to the fact that in the sections you'll see references to municipalities, you'll see references to public body, in the municipality, community association, public recreation commission, or other public body. So I disagree with respect. I disagree with the notion that somehow you're segmenting 22 to be the public bodies and 23 to be private. That's simply not borne out by the legislation. I further submit, with greatest respect, that I couldn't quite. I asked Ms. Baumbach some questions about this notion of double exemption when you're calculating the total municipal assessment, total school assessment. I'm suggesting, Mr. Chairman, that's just simply a non-issue. The legislation is clear. You calculate the total assessment, the total municipal assessment, that is, as all the property, including the property subject to grants, and that's what they would be under in our submission. But then under the total school assessment, you deduct the portion assessment for those properties where the school taxes are not payable. And it's a simple matter. You just deduct the portion value of these properties to the extent I'm suggesting they are exempt in that calculation. So it's the one and the very same calculation that is already done by the assessor. So I'm suggesting that is simply a non-issue and is not double counting. So the only way that Red River College would not be exempt from school taxes is if you find that the word college doesn't include Red River College in section 23. And I submit when you examine the scheme, that simply could not have been or I'm submitting it should not or wasn't the intent of the legislature. Now, in my original statement, what I've suggested to this board, and it's borne out, I suggest, by the entire structure of the PILT and GILT program and how the program was intended to operate, but to suggest that the Red River College should pay 3 times the rate of tax because they're exempt under section 22 is simply not consistent with the fairness and equity provisions that underpin both the assessment legislation and also the GILT and PILT programs. And I ask the board to make what is admittedly a bold decision, and I understand that, but I'm asking the board to make the decision in favor of Red River in this case. And I thank you all for your significant time this afternoon.
Ms. Blomback.
I think she's gone.
Oh, no, I'm here. I just had my video off. I find it sometimes, there I am. I find that having my video off sometimes assists with reception within the Zoom meeting, so I turn it off as a courtesy. So in any event, I don't really have much to add to my submissions from before. They were quite lengthy and quite extensive, so I don't want to delve into those yet again and be redundant. However, I did want to just touch a little bit on the Concordia Hospital case, and I do thank Mr. Reimer for ensuring that that case was available and was before the panel, so thank you for that. As previously indicated, this case is being used by way of analogy to indicate how it is that definitions contained within legislation and the regulations, how they're treated and how they're given some weight in the context of at least court decisions, and in this case, the Manitoba Court of Appeal. So in particular, at section 7 of that particular decision, indeed, it is referring to personal care homes as opposed to hospitals, but I'm just going to, in response to Mr. Reimer's comments on this particular piece, I'm just going to go through it a little more specifically just to show where the analogy is being drawn. So for example, it says the Health Services Insurance Act defines a personal care home as being a personal care home as designated in the regulations. So similarly here, I'm taking it line by line. The Advanced Education Administration Act defines a college for the purposes of section 22. That section is, or that legislation is not referenced in section 23. Then it says the Personal Care Homes Designation Regulation, registered August 11th, 2000, specifically designates Concordia Place as a personal care home. So again, it's the same concept of there's a specific designation of how a particular entity is to be considered or defined for the purposes of interpreting the subject legislation in question. So similarly, in this case, Red River College has been defined under the Advanced Education Administration Act for the purposes as it's being used in the Municipal Assessment Act and also for the purposes of the Municipal Act. And then in this case, it says this resolves the issue of the appeal against the hospital. Concordia Place is by definition and regulation a personal care home, and because of that cannot avail itself of the taxation provisions that apply to hospitals. So essentially it's saying that Concordia Place is by definition something that in this case would fall under section 23 and therefore cannot avail itself of the full exemption in section 22. Now, the analogy that's being derived from this is that in our case, Red River College is by definition a college for the purposes of section 22, which has basically been lifted and reiterated more or less verbatim in the Municipal Act for the purposes of calculating grant amounts. So it is that analogy in terms of the piece saying by definition and regulation, it falls within this category that the city is relying upon. So I just wanted to clarify that piece in response. And further to the comment that Mr. Reimer made in terms of the broad scope versus the more specific scope, it's still respectfully submitted that even if one narrows it to the pieces relating to colleges, Section 22 contemplates one which is statutorily defined, statutorily subject to provincial oversight, it's provincially funded, whereas the distinction being that those colleges that fall under Section 23 and are only subject to a school tax exemption are those which are privately owned unfunded. And this is something that, by way of the examples given by Mr. Reimer relating to Herzing College and Robertson College, by contrast to Red River College, is something that is evident that those items as privately funded institutions are ones that would fall under Section 23, whereas those which are provincially funded and governed and overseen by statute in terms of colleges and universities, for example, those would be captured by the provision that provides for exemptions for both school taxes as well as municipal taxes. So I won't reiterate the totality of my argument that I've already set forth in my primary submissions, but I would like to thank the board for its time in considering this matter and would respectfully request that any finding that be made in favor of the City of Winnipeg and the assessor's position in this matter.
Thank you very much.
You're welcome. Thank you.
Well, this was an application that was unusual, and I thank the two of you for your well-considered arguments and the judicious manner, dare I say, in which you put them forward. So, thank you. Obviously, we will be deliberating and then produce the order, and you will get it as quickly as possible. Thank you very much,
Mr. Chairman.
Thank you, Mr. Chairman.
Thank you.
Lynn and Brent, did you want to just take 2 minutes before we deliberate, or
Yep.
how are you?
Yep, I gotta go move my car, okay?
Okay,
I need a health break. So yes,
all right. I'll watch
Okay.
for when you return.
okay.